Whatever, sir. Yes. Page.
Page 1, 1 to 7.
My lord, item 29.
No.
1 to 7.
1 to 7.
Item number 2, my lord.
कौन है
Permitted to withdraw, my lord.
Kindly give the memo. Number टा mention कर दे. Confusion नहीं जाऊँ बराबर. Page 2, item 8 to 17.
My lord, item 14 may be adjourned, my lord.
अपन कहाँ पे sir?
I'm for petitioner.
Okay. There is a stay order.
No, it has
Defect you have not removed.
my lord. I removed it, my lord.
How much time?
Maybe 2 weeks, my lord.
So adjourn without date, or it has to be given a date given? After 2 weeks, आप 2 सप्ताह परे date देबे?
My lord. My lord.
Virtual court?
Bhavani Patna,
Acha, I'm sorry, actually, I cannot see that insignia, so that's some, maybe my eyesight. Kalahandi at Bhavani Patna?
My lord.
Right?
My lord.
Okay. We commencing?
Dui.
We commencing Dui.
My lord.
Anyone else? Okay. Continue. Quick one to again. Upon कौन एंटी चले चल.
Page 3, 18 to 21.
Item 21.
Again.
And both are ready, my lord.
Again.
Next one is after, man.
Simply posting कर दो.
The entry model.
Entry model पर दरकार extend हवा. ताले अपन को Mr. संग्राम जिन्ना, Mr.
Swine.
Swine is there. Mr. P.N. Mahanti or Swine.
PK
Mahapatra. अपन चैम्बर में अपन पावन. Date केबे करियो?
We consent 27.
27 के 26. We commencing 27.
Entry model.
आपको नोटिस मैटर अपन चूचन ना भूली वाले सब दिन अपन रिमाइंड करे पड़ो. आगे फ्रेश एडमिशन ऑर्डर्स तापरे आफ्टर नोटिस. किंतु अपन फ्रेश को देले 2 आफ्टर नोटिस देले 27. आ जोरे मुंडो हलेले. Anyway, चालू. You have to make an effort. Okay.
Entry model.
To rationalize things. Yes.
Entry model.
Yes. No, that is how otherwise I would have posted. Simply posted, that becomes easier. So, yes.
Page 4, 22 to 28.
Okay.
Page 5, 29 to 37.
29.
Again.
After 1 week.
29, you are Aparanga na madam?
N. Mohanty.
For the petitioner.
Yes, ma'am.
My lord, I am present for the rest.
You agree for adjournment she is seeking. Okay. Kebe chahuchunti? Your name, sir?
Sanket Swarup. It is mentioned S of kindly be changed.
SR Sahoo.
Yes, ma'am.
Or you are writing S.
My lord, in Veena, it is Sanket Swarup, but it is mentioning S Sahu.
SR Sahoo.
S Sahu.
Only S Sahoo you are
My
writing?
name is Sanket Swarup.
No, I'm saying I'm not there, sir. What you write, sir? How do you write your name in abbreviation? Again?
It's Sanket Swarup.
Acha, they have made it Sahoo. Maybe the judge is Sahoo they have mentioned. Yes. Now, surname लगे दिलेंगे अपन. से डेट करो तो क्या?
We consent 2.
26.
Item 31.
31, sir?
I am for the opposite party.
Yes.
I have to file my
You,
objection.
Mr. Sundaray?
I am for the petitioner.
केबे चाहूँगी?
As your lordship.
1 week up. Meeting.
ये डेट करो तो 31 टा?
Entry mode to continue.
We consent 9.
Now do week.
Entry mode to continue.
Yes, interim order to continue. We commencing now do 26.
Obligation.
Yes.
Your lordship.
Item 32 connected matter asini. Therefore, we file the memo
ଆସିନି ଆଜ୍ଞା।
ଜୁଡିସିଆଲ ଅର୍ଡର ନହେଲେ ଆସିବନି ବୋଧେ ଆପଣ ଗୋଟେ
ଆପଣ କହିଥିଲେ ମେମୋଟା ଆମେ ଦେଇଥିଲୁ ରେଜିଷ୍ଟର ଦେଇଥିଲୁ।
ନାଇଁ ସେଇଟା କୁଆଡେ ଗଲା ସେଇଟା ଦେଖିବାକୁ ପଡେ ଆକ୍ଚୁଆଲି ସମ୍ ଟେକ୍ନିକାଲ ଇସ୍ୟୁଜ। ଠିକ ଅଛି ଆଉ ଗୋଟେ ଦିନ କରନ୍ତୁ ସେଇ ମେମୋଟା ଟ୍ରେସ୍ କରିବେ। ଏଇଟା ପରଦିନ ଆସିଥିଲା ମେମୋଟା ଥିବ ସେଟା ଯେହେତୁ ରିଫ୍ଲେକ୍ଟ ହେଇନି ସେଟା ଆଉ ଥରେ ଲିଷ୍ଟ ହେଇଗଲା ମାନେ ସେଟା ଯାଇକି ଫେରିକି ସେକ୍ସନରୁ ଆସିବା ଦରକାର ଯେହେତୁ କାଲି ଛୁଟି ଥିଲା ଗଲାନି ଆଜି ଆଉ ଥରେ ଲିଷ୍ଟ ହେଇଗଲା ଆଉ କେବେ ଗୋଟେ ଡେଟ୍ କରନ୍ତୁ କେବେ ଚାହୁଁଛନ୍ତି
ଏମିତି
22 वीक ना 22 ଆପଣ ଡେଟ୍ वीक କମେନ୍ସିଂ ଆଚ୍ଛା ଡେଟ୍ ବୁଝୁଛନ୍ତି 22 ହବ
ଆଜ୍ଞା।
Your Lordship. Your Lordship, item 37, Your Lordship.
just one second ଏଥିରେ କଣ ଏଣ୍ଟ୍ରି ମୋଡ ଏଠି ତ ସେଟା ତା ସାଙ୍ଗରେ ଲିଷ୍ଟ ହବ that memo would be there but day before yesterday it was quite late so they could not have returned the file almost 10 p.m. actually
ଆଉ ଟିକେ କାଗଜ ଲେଖିଦେଇ
ଆଉ ଯଦି ଲେଖିଦେବେ ଆଉ ସେ ପ୍ରେସ୍ କରିଦେବେ the same day the files are cannot be returned it's not possible if you are expecting the same day it's not possible yes next
Your Lordship, item
37
37, Your Lordship. I am for copy number 1 and 2, Your Lordship, on behalf of S.K. Ruplal, Your Lordship.
ଆପଣଙ୍କ ନାଁ ମ୍ୟାଡାମ
S. Patra, Your Lordship. For adjournment filing counter, Your Lordship, 4 weeks may be granted, Your Lordship. Petitioner counsel is present, Your Lordship.
Mr. Mohanty press for time madam 4 weeks ମାଗୁଛନ୍ତି
Of
Mr. ବାରିକ ଦିଅନ୍ତୁ
9/2 ମୁଁ କାଉଣ୍ଟ 9/2
ତ 4 weeks ହଉନି ଆପଣ ଠିକ ଅଛି 15 22 ହେଲା 29 ହଁ ଠିକ ଅଛି ହଁ 9/2 16/2 ହବ ଆକ୍ଚୁଆଲି 16/2 କରିଦିଅନ୍ତୁ
right, Your Lordship.
ଚେଷ୍ଟା କରନ୍ତୁ ପ୍ରିଡିଂ କମ୍ପ୍ଲିଟ୍ କରିବା ପାଇଁ let us not adjourn the matters at least for some time I will be granting time no difficulty even grace matters also yes ଆପଣ ESI ପାଇଁ ମ୍ୟାଡାମ ପାତ୍ର ESI
My lord.
Yes, Your Lordship.
ଆପଣ ୟୁନିୟନ ପାଇଁ ଆପିୟର କରୁଛନ୍ତି ନା ତେଣୁ yes
No. I am
ଏଣ୍ଟ୍ରି ମର୍ଡର ଅଛି ମିଷ୍ଟର ମହାନ୍ତି
private.
Continue.
Private party OP number 1 and 2.
ଆରେ ତାହେଲେ ସେ ଆଙ୍କୁ ଇନଫର୍ମ କରିବା କଥା ମୋର ଯେ ESI ପାଇଁ ଆପିୟର କରୁଛନ୍ତି
My lord.
କୋଉ ମ୍ୟାଟରଟା 37 ତ
On behalf of S.K. Ruplal. I am
yes ଏସକେ ରୁପଲାଲ ମୁଁ ତ ଦେଖିଲି ସେଟା ପରେ ଆପଣ
ये इनका तो ये से कॉर्पोरेशन तो ये
ସେ ହିଁ ESI ପାଇଁ ମିଷ୍ଟର ମହାନ୍ତି says you are for ESI I mean Ruplal is for ESI
my lord.
ଠିକ ଅଛି
36 38 to 40
Item 39. I am for the OP number 6, my lord. My lord, count 4 weeks time may be granted for the filing of counter, my lord.
Mr. Mohanty Alok Mohanty inform him or else he will be coming after and mentioning that
No, my lord, I will inform you.
you are Mr.
S.R. Achari.
S.R. Acharya counters 4 weeks
My lord,
given date କରନ୍ତୁ
ମୁଁ କାଉଣ୍ଟ 23/2
23/2
I.
yes Mr. Sekhar
Lordship, item 1.
item 1
what happened to you you fell down
No, Your Lordship, I had a vertigo, so I collapsed. So,
but I had a history of what vertigo
No, it was the first time.
I don't want to I mean it's a personal question
it was the first time, Your Lordship.
never first time
Yes, Your Lordship.
you examined everything
Yes, sir.
yes Mr. Sekhar
Item 1, Your Lordship, there are two matters. In the sub-item I am appearing on behalf of Mr. Rautre. I have instructed that in the meantime the petitioner has passed away, so I have to take steps for substitution.
and what about the first one
First one, Your Lordship,
Also same petitioner.
same petitioner, but our office is not appearing in that matter.
ଦେଖନ୍ତୁ 16984 of 2006 BB Rautre has also passed away
Yes, Your Lordship.
24 years 25 years rather Mr. Shakti Sekhar submits that his senior Mr. B. Rautre was engaged by the Learned Instructing Council. So in the meanwhile, the petitioner has unfortunately passed away. It is submitted that the matter may be adjourned to enable obtain instruction and file substitution if so advised. If no one is responding, then we can simply close the matter.
Fine.
After 25 years, you do not know whether they will respond or not. Service matter.
Yes, Lordship.
They may
Release
come up.
of his admitted salary. That is due.
Let us see this. So they will have legal heirs. Mr. D.N. Lenka, 16984 टा आगे लिखुଛନ୍ତି. D.N. Lenka for OP number 1 and 2, AGA, ଆଉ 3 notice नहीं हितला 3 को ना fresh नहीं ଅଛି এটা. मते देखियो. Yes, you can see. No, there is no order actually. Last line लिखो. The second court submission to the पूर्व लिखिए. Though the matter is pending since 2001, notice has not yet been issued. Settler division bench thila, most likely.
Right.
By order dated 15/7/2008, division bench of this court directed for listing the matter along with OJC number 5893 of 2001. Mr. Sekar. Mr. Lenka, anything to say?
Yes, no, one from 4/11/2016, the order was reserved after hearing. Then it was released on 3/1/19.
16984 देखते ଆପଣ?
Yes, sir.
Okay,
16984 by 2006. Connected matter.
କେବେ ରିଜର୍ଭ ହେଇଥିଲା?
4/11/2016. But this our brief search.
ନାଇଁ kindly ଏଠି ଦେଖନ୍ତୁ. Use this. Mr. Sahoo, can you operate that? Yes. Bookmark ଖୋଲନ୍ତୁ. Order number 2 ଖୋଲନ୍ତୁ. ମୋର order number 2 ଛଡା in fact Mr. Sekar is also not aware. କଣ ଆଉ ଗୋଟେ କୋଉ କେସରେ ଲେଖା ହେଇଯାଇଥିବ. ଟୁଟା ଟଚ୍ କର. ସେତିକି ଆଉ କିଛି ଦେଖୁନି. So, Mr. Lenka, apparently there is no such order.
No, sir. But
ସେଟା ସେ କଣ ବହୁତ ଗୁଡେ ହେଇଗଲେ ବେଳେ ବେଳେ ଆମେ ଯୋଉ ଡିକ୍ଟେସନ ବି ଦଉଛୁ ସେ ଆଉ ଗୋଟେ ଫାଇଲରେ ନେକ୍ସଟ ଫାଇଲରେ ଲେଖି ଦଉଛନ୍ତି. ଜଣା ପଡୁନି.
yes, sir.
ହେଇପାରେ. ମଝିରେ 400 ମ୍ୟାଟର ଲିଷ୍ଟ ହେଲା 200 ମ୍ୟାଟର ଲିଷ୍ଟ ହଉଛି. ଷ୍ଟେଟ କାଉନସିଲଙ୍କର ରିଏଲି ଡିଫିକଲ୍ଟି ହୁଏ ଅର୍ଡର ସିଟ୍ କମ୍ପ୍ଲିଟ କରିବା.
Yes.
Then second ଲେଖନ୍ତୁ OJC 5893 of 2001. The matter is listed along with the petition is listed along with WPC number 16984 of 2006. In view of the order passed therein, upon date for the complete order to complete. Last step. Accordingly, it is submitted. It's so advised. Not it advised. It's so advised. How much time, Mr. Sekar?
3 weeks maybe.
3 weeks for a list on. We commencing na केमती करिए? We commence. ठीक है. List on we commencing दुई.
Yes.
Now चाहते हैं.
9.
अच्छा 9 दुई. 9 दुई. Five 893 जोड़ा नहीं की. It's लिखिए the advocates who had filed वकालतनामा, their name has been mentioned. None appears when the matter is called. Yes.
Item to
Mr. Siddharth Samal for the petitioner. Opposite party blank. The petitioner files memo of date. Memo of date which is taken on record. The memo indicates the following. Quote kar dele. The petition is disposed of accordingly.
Item 3,
May please, Your Honor.
Yes.
But after 35 years of marriage, my lord, the petitioner and his and her son, my lord, was driven out from the matrimonial house, and petition was 125 application was filed for claiming maintenance of 15,000 per month and 10,000 for study expenses of her son and litigation expense 10,000. But Annexure 1, the family judge has only granted 3,000 per month maintenance.
Mr. Bhavan Manti for the petitioner, opposite party blank.
Same disposal with the
The petitioner, the plural petitioners, not
Petitioners,
the petitioners, mother and son.
son.
But he's a
Major, my lord.
major. How you will claim? Which act?
He is studying and totally dependent upon her mother, my lord.
Not after 18.
That's correct. The study expenses is also borne by.
That is the flaw in filing the petition. That has frustrated the whole purpose. You see, a good case has been made a bad case by impleading by the major son of 25 years of age claiming maintenance from father.
Unless he is a mental retarded.
There is
Nothing.
there is nothing which provision the court will resort to. The trial court, which provision can give maintenance? Unless,
No,
unless as you said, retarded or some physically handicapped or that kind of a situation.
the family could have discarded that part. That claim of maintenance by the.
It's a very wrong strategy, actually.
But all the expenses.
You can't sustain, actually. That's the problem. That is how the court got suspicious, might have got suspicious and. You should have confined the petition to only the mother, wife. Mother and son are before this court, challenging the order dated 14/11/2022 passed by the honorable judge. Family Court Jajpur in criminal proceeding number 98 of 2019. By the said judgment, the learned court, though allowed the petition filed by the petitioners herein, claiming maintenance under section 125 CRPC into brackets since repealed. But the amount claimed by the petitioner number one wife, rupees 15,000 per month, was not granted, and the amount has been fixed at
3,000 per month.
3,000 per month. So, hence this petition challenging the judgment. Dated 14/11/22. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 working days, Mr. Mohanty?
Yes.
Within 5 working days. List after SR, liberty to mention. The petitioner number 1 shall continue to collect the amount of rupees 3,000. Receive. Without prejudice to her rights and contentions in the present petition.
I filed an interim application. The 3,000 may be deposited in our account by the.
How do you know, sir? I'm not executing court.
That
High Court, how it will become executing court of the family court? You have to file execution there. Last line ta kaun suni leta? What is the last line of order? Petitioner shall continue to receive the amount, petition number 1. Shall continue to receive the amount of 3,000 without prejudice to her rights and contentions of in this petition. So if you want execution, file there. If you have a dilemma to execute or to challenge, that I have clarified without you asking me. I mean asking the court rather. Yes.
Item 4.
Raise on adjournment, Lordship.
Mr. P.K. Malik.
Yes, Lordship.
So P.K. Malik for the petitioner, opposite party blank, the learned counsel for the petitioner 6 and has adjournment for obtaining instruction. List. কেবে স্যার কোন
February, first week of February, Lordship.
in the week commencing 2-2 হব 2-2-2026
Public.
Item 5,
May I please, your lordship? I'm in virtual mode, my lord.
your
I may allow to place this application on behalf of Mr. S.K. Ponda, my lord.
Mr.
Rajiv Lochan.
Rajiv Lochan Patnaik on behalf of S.K. Ponda for the petitioner.
My lord.
For the petitioner, the learned counsel, Mr. Patnaik submits that he may be allowed to submit on behalf of the learned counsel, Mr. S.K. Ponda. Leave granted. Tafar Lekhu. Yes, next. Yes, please, Mr. Patnaik.
Yes, my lord. The present petitioner is the wife of the opposite party, my lord, and challenging the order dated 26/5/2025, where the family court allowed maintenance for ₹9,000. However, the opposite party working as senior revenue assistant and getting salary, my lord, 46,000, my lord.
So very good, sir. 1/3 is for a single person is a good. This prolonged litigation will not help them.
My lord.
9,000 is a good amount
But my lord,
because and the 125 is in the nature of an interim arrangement. Is there any petition pending? 13, section 13, section 9?
no, my lord, no, my lord.
Okay.
Only issue notice, your lordship.
This doesn't lead anywhere there. That's the problem. The petitioner wife is before this court challenging the order, the judgment, challenging the order dated 26/5/2025 passed by the learned judge, Family Court Jharsuguda in CMC number 24 of 2023. By the said order, the learned judge, Family Court has allowed the petition filed by the petitioner herein under section 125 CRPC since repealed and granted monthly maintenance of ₹9,000 instead of 20,000 claimed by the petitioner. Stuff heads the petition. Para issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within
5 days, my lord.
within 5 working days. List after SR, liberty to mention. It is further directed that the petitioner shall receive the amount of ₹9,000 as granted by the learned judge, Family Court, without prejudice to her rights and contentions in the present petition. List after SR, liberty to mention. List after SR, liberty to mention.
Yes, your lordship. Oblige, your lord.
item 6,
So Dayananda Mahapatra, senior advocate, along with Mr. R. Pradhan for the Mr. J. Barik for the petitioner. Mr. M.R. Pradhan. Sorry, M.R. Pradhan. They have filed a caveat.
No. They appeared, my lords, on the date, my lords, it was taken up for face submission.
Achha. So Mr. Mahapatra, can you accommodate and we pass it over or we'll adjourn it?
Yes,
Mahanti.
Instruction ଆସିନି
ଆଜ୍ଞା
instruction not received mail
ଆଉ ସମୟ ଚାହୁଁଛନ୍ତି
Yes.
ଆପଣଙ୍କ ନାଁ ସାର୍
opposite pet number 2 and 4 mail
and the corporation.
Yes, Lord. We can see order dated 7/1/26.
yes
On the last date, my lord, the case was taken up for fresh year admission, my lords.
yes
My friend Mr. Misra has appeared in this, and he is aware of the fact that procurement of paddy will commence from 19th. And unless target given from that balance, so it cannot be. And the target once given it existed, my case will be infructuous.
my lord petitioner
ଦେଖୁନାହାନ୍ତି ପ୍ରୋକ୍ୟୁରମେଣ୍ଟ ହଉନି ବୋଲି ବର୍ତ୍ତମାନ ଚାଲିଛି ବହୁତ
ସେ ଚାଲିଛି procurement
ଆପଣ ଏମିତି କେସ୍ ବାସ୍ କରି କରାନ୍ତୁ ପ୍ରୋକ୍ୟୁରମେଣ୍ଟ
in the district of Jagatsinghpur, my lord, they fixed the procurement on 19th. May my lord let them.
ହେଇପାରୁନି କୋଉଠି ବି ହେଇପାରୁନି ଠିକରେ ହେଇପାରୁନି
ଠିକ ଅଛି, let it be taken up on 19th.
yes
He got a
Today is 15th. 19th ରେ ରଖନ୍ତୁନି there will be some difficulty also 22nd
26 टार्गेट जी थोड़ा सरीजिबा
टार्गेट कौन सर जो पेंडेंसी आपनकर
ତାଙ୍କର
ସେଇଟା କ୍ଲାରିଫାଏ କରିଦଉଛି
ଆଜ୍ଞା
ସେଇଟା କ୍ଲାରିଫାଏ କରିଦଉଛି ସେତିକି କାରଣ ସି ଟାଇମ ନଉଛନ୍ତି ଯେହେତୁ ଲେଖିଲେ appearance sir your name Palta Singh
Yes, Paltasi.
Mr. S Palta Singh for the Mr. Danidilenka IGA for OP number 1
1, 3 and 4.
1 and 3
1, 3 and 4 also.
1 3 and 4 हाँ तेरे से 4 अपन मैनेजर पर
Yes, sir.
4
One and
मैनेजर
three.
मिश्रा
3
Yes, sir. One,
3 भी आप एक्चुअली सी रिप्रेजेंट करेगा था क्या ना कलेक्टर एज कैपेबल एज हेड ऑफ द ये
well,
civil supply 1 and 3 Mr. Samir Misra senior advocate along with Mr. Palta Singh is Palota Singh for OP number 2 and 4 the learned counsel Mr. Palta Singh seeks a further adjournment to obtain instruction Para. It is submitted by Mr. Mahapatra and senior counsel that earlier the matter was adjourned on 7/1/2026 at the instance of the learned counsel for the at the instance of the OP number 2 and 4. 2 and 4. In the meanwhile, the procurement of paddy,
in the district of Jagatsinghpur
procurement of paddy, paddy in the district of Jagatsinghpur has been scheduled to be started on 19th of January 2026. Since Mr. Palta Singh seeks further time to obtain instruction, it is clarified that adjournment of the matter shall not in any manner prejudice the petitioner or his contentions and right to consider leave na kon asida. What is that? Apan kon karibe?
will produce CMR right to procure paddy
Right to procure paddy. Procure paddy setik thau.
pendency of the case already bar to consider my lord.
Okay. It is further clarified that pendency of this petition in no way shall be a bar for the authorities to consider the grievance of the petitioner to allow him to procure paddy
on furnishing my bank guarantee
on furnishing bank guarantee
as required.
as to the satisfaction of the authority. The authority shall have the freedom to decide the matter on its own merit in accordance with law. This on 22
Yes.
22 तारीख ना 21
Equipment.
21
Equipment. It will be
Item 7.
Mr. Lekka asi to Mr. Palta Singh and Mr. Lekka आपण जदी आपण चिठी करि पारि से आपण चिठी करन तुटी.
Yes.
Try to resolve the matter. You have a duty, sir.
Yes.
Yes.
we have also,
Right?
last time also we had sent a letter, no instruction has been issued. I'll send a
See, thank you. CBS corporation, I think, is the authority.
no means collector is to distribute matter. So with the help of district manager means civil
Collector
supply.
hits that civil supply, public distribution and civil supply.
They wanted to keep these paddy millers for processing to other districts. I am a new miller.
Parties to act upon production of the copy of the order obtained from the official website.
Right.
Produce current.
Right.
The Prince Patnaik for the petitioner.
May I please, Lordship? Lordship, the innocuous prayer of the present petitioner, Lordship, is for time-bound disposal of the MIT case pending with the learned familiar senior division, Lordship.
No, I am not prioritizing any matter whoever approaching is High Court. The reason being, in the administrative, we have instructed the courts to follow the strict year-wise rule.
Manner.
Unless you come up a case that's the only case pending before the learned judge, then you see, suppose the same district, I am the administrative judge.
Manner.
I instruct that you follow the strictly, don't, all matters should be taken up seriatim or whatever prioritized basis. Now in the judicial side, they issue order, they have come. So you move the court, let them consider it according to their pendency.
My Lord, the difficulty is the petitioner is working in USA, Lordship. And because of this pending case, Lordship, he is forced to...
Working in USA cannot be mandate for the any court in India to expedite the matter.
No, Manner.
Please appreciate this. So let's pass that order. Then the other side will challenge that in Supreme Court.
I bow down, Manner.
So the difficulty, is it sustainable?
My Lord, another...
So let us be specific in our approach as far as judicial issues are concerned.
My Lord.
So working in US is a choice.
My Lord. And my lord, further, my lord, examination, evidence, and also on the side of the petitioner and the opposite party, it is over, lordship. Cross-examination also over.
Whatever, I cannot presume that the learned judge is sitting about the matter.
My lord. And lordship,
And
next
it will be
operations
elaborating
also.
because it is for all to consider, all of you.
My lord.
I cannot presume that the judge is sitting over the matter.
My lord,
Because you know what happens.
My lord.
When district judges are literally chasing lawyers to argue matters.
My lord.
It has gone to that extent also. Because adjournment is a problem everywhere. High Court is much better actually. Here actually matters are less urgent perhaps. Though there are adjournments, but matters are taken up. And there is a list system. Every day there are some 40 matters. So one matter is adjourned and other matter is taken up. But in trial court, it is really...
My lord, I have annexed the order sheet for a kind perusal. Lordship may have a glance. Repeatedly, on some pretext or the other, you have to prolong the litigation.
For that, you have to file a petition.
My lord.
There is a specific provision in CPC whenever the petitioner appears, opposite party abstains. Then what the court will do? You file that petition, let an order be passed, something should be done. But this can't be done on the basis of presumption that the court is not taking up or the other side is delaying the matter. And issuing notice here again, the matter gets stalled. Any matter which is taken up by this court, the lower court will be hesitant to take up the matter. Yes, what do you say? I'll simply... Yes, what do you say? I'll simply observe that you'll move the court. And Mr. Patnaik, Learned Counsel for the petitioner. It is submitted that due to pendency of the matter, the petitioner is put to difficulty as he works.
He, my lord.
Sorry?
He, my lord.
As he, yes,
My lord.
as he works.
My lord.
As he works in... You are back to work. Sure, confident upon. As he works in US. Para. It is further submitted that the opposite party has taken several adjournments in the matter. Para. In considered view of this court, the matter cannot be targeted at the instance of a particular party to the litigation. Stop. However, such an order would amount to prioritizing a case at the cost of other litigation pending before the learned court in season of the matter. Stop. However, the petitioner, if so advised, shall move the learned court for taking up of the matter, subject to the pendency of the cases before the said court. The petition is disposed of accordingly. Urgent certified copy.
Item 8.
Please, your lordship.
Yes, Ms.
Your lordship, the petitioner husband, your lordship, prays for transfer the criminal miscase number 248 of 2025 from
125.
Yeah.
Read 126.
25, your lordship.
Again?
Your lordship, 248 of 2025, your lordship.
What is the petition to be transferred?
Your lordship.
144.
Your lordship.
Nagarika
Your
Suraksha
lordship, maintenance, your lordship. 144 of BNSS.
Look at 145. What a boy achi. Boy achi.
Your Lordship.
Hmm.
Procedure.
ପାଇଲେ
Your Lordship.
145 ପଢନ୍ତୁ.
Your Lordship. Proceeding.
Kindly speak to the microphone. Microphone ଟା ବ୍ୟବହାର କର. Miss Sulochana Patra for the
Your
petitioner.
Lordship. Proceeding under section 144 may be taken against any person in any district where he or she or where he, his wife is reside.
So what is the interpretation of that? How this scope will change the 145?
If his reside there. Your Lordship.
He wherever he resides or his wife resides.
Resides.
So how can court change it?
Your Lordship, the petitioner also working as a private company, Your Lordship, when
Private or public limited company. 145, then you find out in 145 where employee of private company is a given exception. He may work in US like the last matter of Mr. Patnaik.
Your Lordship, the petitioner also filed in Barampur. He also a Ganjam district petitioner also.
125 is a principle applicable no.
Also going to settle this matter, Your Lordship, refer to Your Lordship.
Nothing.
Refer to mediation center, Your Lordship.
No. What is the scope for 125 to refer to mediation? 128 पढ़ନ୍ତୁ. A magistrate, पाइले?
Okay.
A magistrate? D ପରେ ଦେଖନ୍ତୁ.
Provide that if the magistrate is satisfied that the person against whom an order or payment of maintenance.
ଏଟା ଆଉ ଗୋଟେ କଣ ପଢୁଛନ୍ତି? A magistrate of the first class may, upon proof of such neglect or refusal, order such majority where such child is by reason of any physical whatever. So there is no scope for this mediation. 125 criminal procedure code और भागरिक भारतीय BNSS रे mediation रो कोड scope अछि. The section is frustrated. 13, 9, 25, 24, all those things are different. Or that adoption and maintenance, that is different. But 125, there is no scope for mediation. 125 ର order ଟା ଆଣନ୍ତୁ. ବହୁତ ଯୋଡା ଆଗରୁ judgment ଅଛି. ठीक ଅଛି. I'll dispose it off.
Your Lordship, the petitioner.
This law of frustrating a 125 proceeding by filing a TRPCRL cannot be allowed.
Your Lordship,
There is no such power for the High Court to transfer because 145.4 has to be read with 145 and mediation there is no scope.
Your Lordship, the petitioner filed before the CP case number in Barampur Family Court, Your Lordship. The opposite party wife also filed TRPC to transfer this matter to Nayagarh, Your Lordship. See, that case also is pending, Your Lordship, in this before this court.
How does it matter?
That are related.
Let us consider the legal nuances of a subject should be considered. It should not be converted to a drawing room discussion. किए कौन करछंती किए कोठी फाइल कला. If you have a legal point, then address so that I'll get educated. Okay. If a case is filed for transfer of CP, then 125 has to also be stayed or transferred. Should be sent for mediation. Make that submission. Enrich your submission by citing some case law. Could be, I don't know. At least I'm a student of law, like the great Nariman has said. Once a student of law, continue to be a student of law. But with my level of understanding, I am finding there is absolutely no reason to interfere. And what about 145 or 126 in the CRPC? How it is to be interpreted? She will get it upon proof of neglect and she can file wherever she stays. Cannot be. Sulochana Patra for the petitioner, opposite party blank. the petition has been filed seeking transfer of the petition filed under section 144 of the Bharatiya Nagarika Suraksha Samhita. Petition has been filed under section 447 of the BNSS. For transferring CRL miss case number 248 of 2025, filed by the opposite party wife in the marriage before the Lord Judge, Family Court, Noyagarh. It is submitted that the petitioner husband in the marriage works at Uttarakhand. One koile?
Uttar Pradesh.
Works in Greater Noida, Uttar Pradesh in a private company. Though his permanent residence in Odisha is at Barampur. At Gandhinagar, Barampur in the district of Ganjam. Stop. The learned counsel for the petitioner was asked to respond to the provisions contained in section 146 of 145 of BNSS, which are reproduced herein. In view of the specific provision contained in section 145 of the BNSS, this court is not inclined to direct transfer of the petition filed under section 125 CRPC. Accordingly, the petition is dismissed. Copy of this order shall be forwarded to the Learned Judge, Family Court,
Noyagarh.
to be tagged to the file of CRLMP 248 of 2025. If there is a CP, one more thing, if there is a 24 petition pending, there you can take this plea that 125 is already there. Which judgment? Because I have to go to that side to assist you. Which judgment says so? That all petitions are to be taken up. Now it has become very famous, Rajneesh versus Neha. Yes.
Item 9.
Mr. A.K. Behra for the petitioner. Yes, please.
Not the division is against the expert order of maintenance. The opposite party is claiming to be the wife and son of this present petitioner.
And the petitioner doesn't know them to be wife and son.
No.
So it's a case of claim and counterclaim. How the court will believe whom?
Because it's an expert order, I have prepared.
Have you filed a petition for setting as an ex parte?
Yes, tomorrow is the date is fixed. I have already prepared all those petitions on section 146 and section 7 of Family Courts Act to refer the DNA for claiming to the because the
one adjournment.
No, adjournment. I am ready to deposit the 50% of area which has been awarded, and your lordship make state.
Unless you deposit, I will not.
To within a period of 4 weeks, I am ready.
You see,
why
the husband saying that she is not my wife, and he is not my son, is not a ground. I will pass a order. Please appreciate.
That can
my orders become laughable.
That cannot
be. Because
so
as far as your duty to satisfy the decree, Again, if I say that you did not satisfy the decree, I am still more laughable.
Within a period, I undertake. Within 2 weeks.
No, you should have by now.
Subject to deposit because I am married since 1998. I have 2 daughters. They are doing job.
Marrying thrice or 4 times is not again still further laughable. You see, if I record your submissions, Mr. Behra, you must understand. I am a court. Not more than a court. Nothing more, nothing less.
Yes.
So if I start recording, the petitioner submits that he is married since 1998. 2 daughters are there. So this lady's claim has to be rejected. These are all laughable. These are all laughable orders. Don't make that your officer of a court.
The observation in
You see, it has to be strictly in legal parlance.
Yes.
It cannot be.
Yes, I am coming
It cannot
to
be.
that point. Because without any proof, without any marriage has not.
Sir, you challenge that. You challenge that before the court, which has passed the order by seeking setting aside of decree. So it is the best defense that this is not my not decree setting aside of ex parte order.
Yes.
So you deposit that amount.
I will deposit tomorrow. Is the date is fixed. I have already prepared all those petitions.
You deposit 50% there.
Yes, there. That's.
Sir, tomorrow the date is fixed for who, what, and which case? That you are not saying.
For filing the execution case.
You deposit in the execution.
In execution case, I will deposit tomorrow.
Yes.
And all those petitions till.
Sir, kindly listen, sir. You are submitting without listening to the court. These things I cannot record to pass a order. That is the first difficulty. Second difficulty, if you want to satisfy 50% of the decree, it is at your choice.
Execution means.
So execution, the court will accept that 50% and release the amount. Then
my humble prayer before your lordship, that amount may be kept till the disposal of the petition.
No.
Because it is not a marriage. It is no relation.
Sir, when we are set ex parte, all these things those are not before me. That is the other. I did not purposefully. I did not ask you. That would lead to dismissal of your petition. You have not produced any iota of any order. When you were set ex parte, what was the prior order? What was the second order? You approach the court most recklessly, not as a lawyer. These things you should have asked to the petitioner. On that ground alone, this should be dismissed actually.
I have already, because on 18, the date was fixed.
So taking chance with courts has a limitation.
I have already applied.
You are saying that it is an ex parte decree, but how can I conclude that without anything? So why? So now the question comes to the court's mind. Why this order has not been produced before this court? What could be the purpose? It is as simple as that.
I have already applied for. Because
when you can get the copy of the latter order, it is much easier to get the prior order. So these things, this can't be second guessed. Second guess kari habani. Which portion? Sabutere andasta kale. Nothing.
Because it is situation is different.
See bujibe. If he comes up with a good case transparent before the lawyer, what is the difficulty for a lawyer to produce that? It is his choice for not producing the order and challenging it.
Till the disposal of
nothing unless you produce. Now I have to record that you have not produced when you were set ex parte, the rescind order, and when the petition was filed for setting as an ex parte order.
Within 2-3 days, I will get
that. You find
tomorrow is the deadline. I will get tomorrow.
No, nothing. I will not pay party to the activity of this petitioner, because that would result in the court participating there.
Yes,
I should not, because it can't be done like that.
Because the execution proceeding.
Anyway, you have done your best. The execution proceeding to be stayed. You have not produced the certified copy of the entire order sheet when you were set ex parte. When did you file the petition? What is the order of the court on that petition? Those 2 things I require. Even I pass it over. I pass it over. If you produce those two things, entire order sheet and the order passed by the court accepting that petition for setting aside ex parte decree. Order. Decree, no order. I'll pass it over. No difficulty. So this ploy of frustrating court's process cannot happen.
In IA, I have filed the notice and the petition of execution procedure.
Execution, I'm not asking you.
And
a court enforcing a order by execution cannot be faulted with. It should not be stayed also. And it's a money decree. Money orders are directing for deposit of money.
Yes.
You have to disclose before this court the entire order sheet, when you were set ex parte, and when did you file the petition, and what is the order on that. I am passing it over.
Yes, I'll
You produce it entire thing.
because it
Even photocopy, I don't mind. I'll record that you are relying on the photocopy. I mean, at least some semblance of record is there. ଯେମିତି କରିବେ ଆପଣ ଯୋଉ ତାମାନେ so he has fooled you. Your client has fooled you. He has not shown you the copy of the order setting him ex parte, but you have filed a petition setting alleging that he has been set ex parte.
because ex parte
There cannot be any cause. There cannot be any cause to say because. Mr. Behra, you must understand the limitation of a court. Court passing orders, spirit of the facts, spirit of law is very difficult, Mr. Behra. I will be completely out of, beyond purview of law in dealing matters like this. No semblance of material on record, nothing. I simply observe that it is ex parte order and stayed. Where is the material?
lawsuit can it be fixed?
Since you are saying I have no difficulty in adjourning, but since you are saying tomorrow, that I am saying that I can pass it over. Hopefully, you will produce that. This for you.
I can only the PDF copy. I can tell my friend.
Whatever you sign it and file it. That is how to take. That is your baby. You should take care of the baby. Court has nothing to do with that.
Yes.
How do you do it? I'm passing it over.
Yes.
The entire order sheet. By which order you are set ex parte? Order 1 to till the order. This is order dated. This is judgment. This is final
judgment.
And when did you file the petition for setting aside? And what is the order on that?
As tomorrow I am going to file because I have already prepared all those petitions because tomorrow is the date.
Let the court proceed.
Not the person who has no nexus, no relationship.
Supreme Court has issued a guideline. That order has been circulated. Execution cannot be kept pending.
I don't.
That you are after the execution, not after the main case.
The main case.
So you take steps in the main case.
Tomorrow is the date to pay.
It was yesterday. Does it improve the case? Suppose yesterday was execution. Today I am taking up the matter. Does it improve the case? Because you are not addressing the main case. I have to address the main case instead of execution.
Yes.
For interfering in the execution, I have to address the main case.
Yes.
Order kept to Elani.
Order Elani.
ବର୍ଷେ ହେଇଗଲାଣି
ଆଜ୍ଞା because as the execution proceeding notice has been received, that is why on the matter was fixed on 8. I have appeared there.
Anyway, I am passing so nothing can be done. Mr. ଲେଖିଲେ
pass over ମୁଁ କହୁଛି
ଡ୍ରାଫ୍ଟ ଅର୍ଡରଟା ଥାଉ ତାପରେ ଆପଣ ଯାହା କରିବେ. The petitioner husband, you take your seat. Take your seat. Petitioner husband in the marriage challenges the order. The judgment dated 24/2/2025 passed by the learned judge, family court, Kendrapada. In a petition filed under section 125 of the CRPC, filed by the petitioner, filed by the opposite party, filed by the opposite parties, mother and son, claiming to be the legally married wife of the petitioner, who was the opposite party before the learned judge, family court. At paragraph 2 of the said judgment, the following has been indicated. At paragraph 3, it has been stated that notice was sufficient. Summons were issued to the opposite party petitioner, which was sufficient. He did not appear. And he was set ex parte with the order dated 5/1/2024.
5/1/24.
1 year is over. 2 years are over. At this stage, it is not at this stage. It is submitted by the counsel for the petitioner that the petitioner is now facing execution of the said judgment dated 24/2/25, the execution.
Execution, CRP execution number
28/25. 2025. The Supreme Court decision like in so and so. The apex court have directed the execution cases should not be kept pending. Rahul Shah. RHUL SAW with an SH. Rahul Shah citation dang dev. It is the learned counsel for the petitioner submits that the petitioner disputes the marriage. Should I write Mr. Behra that he is married to another lady and has begotten 2 daughters?
Marriage since 98, marriage certificate is there. Not annexed.
Sir, certificate I am not asking. You are disputing the marriage and married to another lady will lead to some problem.
Disputing the marriage.
That risk you will take.
I am disputing the marriage.
When you call it disputes the marriage, and it is further submitted that the petitioner has married to another lady and there are two children are born of the said wedlock. At this stage, this court would not interfere in the execution proceeding pending before the learned court. It is submitted by the learned counsel for the petitioner that the petitioner will file petition for recall of order past ex parte. However, this court expresses no opinion on the said aspect of the matter. The matter is adjourned. केबे चाहूँ आपण जदि पास ओवर करि पारिबे आनी पारिबे नो डिफिकल्टी इट्स ओनली अ ड्राफ्ट ऑर्डर बिकॉज़ आई विल हैव टू रिपीट द स्पेंड द होल टाइम इन डिक्टेटिंग आपण जदि आनिबे ताल डेट कहि थांतो से डेटा एटा रहिबो आपण
हां नले 20 19 20 तारिख
20 मिस्टर 20 1 20 26
20 तारिख तो सो दैट
जदि आपण आनी मेंशन करिवे सेटा पाइबे पूराटा एवं पिटिशन पाइबे ताले आई सी
काहे ना आज डेट
से कटक रे रहि कि आउ थरे से जो typical problem of getting married, staying at different places and undertaking marriages has happened. Most likely.
It's a different. I cannot express in.
No, not. What is there not to?
I can only in other word. दुकान रो विभिन्न कस्टमर जाउछन.
नहीं.
से मैं काइंड
don't make loose statements in.
That is why I don't.
आपन petition आपन actually आपन ये करछोंदी. Petition आपन पढी नांत. ठीक है, leave it there. Yes, next.
Item 10.
सेटा पास ओवर पाई आपनकर से बुझ पर नांती बोते पास ओवर माने से पास ओवर इतने वाला जदि आपण पिटिशन दा पाइबे ऑर्डर एंटायर ऑर्डर शीट पाइबे ताले आई लुक एट दैट
पास
मगे दी पास जेमति मगेबे सेटा आपण सुनलेनी बोदे से जा कहिचनी मगेबे ताकू से आपण कोर्ट रे फाइल करिवे विथ मेमो दैट इज योर रिस्पांसिबिलिटी
पास ओवर थाउ जदि न हेला ताले
सेटा ड्राफ्ट ऑर्डर रहला
Item 10.
my lord.
Upon only thing you can, what you should have said, again, after I have dictated the order, your submission should have been that without prejudice, You will pay the amount.
Yes,
You produce your rights and contentions before the other court.
That I want. That
That I want after I have dictated, I have told you. What you want, I have told you, not you have told you. So ସେଟା ଆସୁ
Report କରିବାକୁ ready ଅଛି without.
ନା release ହେଇଯିବ. That will be released without prejudice to your rights and contentions.
ହଁ ସେଟା ନହେଲେ ସେତିକି ହେଲେ ବି ହନ୍ତା.
ସେଟା ହନ୍ତା ଯେ ସେଟା ତ ବର୍ତ୍ତମାନ ଆପଣ କହିଲେନି ବୋଲି ତ ମୁଁ ଆପଣଙ୍କୁ ଆଉ ସଜେଷ୍ଟ କଲି ଆପଣଙ୍କର ଡିସ୍କସନ କଲେ ଆପଣ ତିନି ଜଣ ଡିସ୍କସନ କଲେ ମତେ ପାର୍ଟିସିପେଟ କରେ ସେଥିପାଇଁ ମୁଁ ଡିକ୍ଟେଟ୍ କଲା ପରେ ମୁଁ ପାର୍ଟିସିପେଟ କଲି ଠିକ ଅଛି leave it there may Mr. Swarup for the petitioner.
My lord, hearing I have filed this writ for expedite hearing of this civil
order as in Mr. Patnaik.
My lord, I have heard my lord's view. My lord,
it's not my view, these are facts. My view I can have when I have beyond the facts and discuss the facts.
I have only a few submission. My lord, the petitioner's examination was over on 10/9/2024. Thereafter, 500 days have passed. And she has not yet filed her.
I will not become a family judge.
My lord.
You educate the family judge, file a petition. I have a difficulty in becoming step into the shoes of a family judge and passing orders. Since 500 days have passed and all these things, they should be done. Whatever has happened, it is your duty as a counsel, petitioner as a duty as a litigant to bring to the notice of the court. Then the court may pass a illegal order, wrong order. Then you come here. That though I have brought to the notice of the court is not responding. That can't be any presumption. And expediting matters is not a matter of right as far as the cost of other litigations. ତାପରେ ଆପଣଙ୍କର ଆଉ ଗୋଟେ ଭୁଲ କଥା କହିଲେ 500 days ପରେ କେତେଟା କେସ୍ ଅଛି ସେ କୋର୍ଟରେ
ବହୁତ ଅଛି.
Then your argument falls flat on its face.
My lord,
ଆପଣଙ୍କ 500 days ସବୁ ଯାକ କେସ୍ it's not the law. So 500 days ପରେ ସେଟା ଅଲଗା ଲେଭେଲ ଆସିଗଲା like listed 20 years priority 25 ବର୍ଷ ପୁରୁଣା କେସ୍ ଲିଷ୍ଟ ହେଲା. Still it could not be disposed of.
500 ଦିନ ତାଙ୍କୁ ସମୟ ଦିଆଲାଣି ସାକ୍ଷୀ ଦେବା ପାଇଁ.
ହେଇଥିବ
ଲାଷ୍ଟ ଡେଟ୍ 70 ଦିନ.
1000 ଦିନ ନଉଛନ୍ତି 1000 ଦିନ ଚାଲୁନଥିଲା ଆଜ୍ଞା ସୁଟ୍ କିନ୍ତୁ 80 ବର୍ଷ ହେଲା ପେଣ୍ଡିଂ ଅଛି 100 ବର୍ଷ ହେଲା ପେଣ୍ଡିଂ ଅଛି
ସବୁ.
So that is part of the litigation process. And does it happen like a instant thing? It doesn't happen. You have to follow the procedure. And a small mistake in principle of natural justice, not affording opportunity, results in setting aside of the entire order. That you also must have. So you bring it to the notice of the court.
My lord,
ଆପଣ ଯୋଉ ଯେତେବେଳେ କହିଲେ ଯେ the court is indulgent to the other side, first you ask the court that why you are indulgent. Let the court answer it. Then you come here.
My lord, on the last date also, about 2 months date was given. My lord, only direction that
ଆପଣଙ୍କର 2 months ଭିତରେ ଯଦି ଅନ୍ୟ କେସ୍ ଥିବ then what is the wrong in there? 2 months date ଦେଲେ କ'ଣ ଅସୁବିଧା ହେଲା? 25 ବର୍ଷ ପରେ ଆପଣ ଆଡଜର୍ନମେଣ୍ଟ ନେଲେ ଅଛି ନା ନାଇଁ ଆପଣ ମାନେ ଆପଣଙ୍କ ଓକିଲ ବନ୍ଧୁ କାଇଁ 25 ବର୍ଷ ପରେ ନଉଛନ୍ତି ଆଡଜର୍ନମେଣ୍ଟ? What for? Is it not a huge criticism that pendency is before the courts? Courts are not up to it. But today a matter has been adjourned after 25 years.
But for
so ଆପଣ 200 ଦିନ କହୁଛନ୍ତି. Oh, you have to be balanced in your approach. When the other side you are taking time, and that you are utilizing when in this side, saying that the other side is taking time. The party is not represented by a lawyer.
My lord,
and that is a strategy. The case is filed without filing the entire order sheet. So we are spending 15 minutes time for discussing that. Please appreciate these are the parts of the entire thing. It comes in a package. ଆପଣଙ୍କର ଯଦି you have the only case, the judge has the only case, you are the only litigant, it is not taken up 500 days, 200 days, it has to be. Then the judge is sitting. Please appreciate that.
My lord, my only submission is directed to fix short dates and only
no discrimination for the litigants. I will pass discriminating other litigants. I'll record. If you say, I'll record that I have pointedly asked you that is this the only case pending after 500 days, 200 days date is fixed. Your answer is emphatic no.
My lord, then court should grant them time only with sufficient ground, my lord, because without mentioning any reason.
Please don't convert me to the family court. I cannot become. There is a limitation for the court to behave like a family judge and guide that the family courts have to be behave like this and that. If you have a petition, then I have to record the reasons. Yes, I'll record that you have not moved the court for expeditious or moved any petition where objecting the adjournment. Where is that petition?
I will move then, my lord, my grant.
Where today in your petition you have annexed that petition, the court has not passed order. Then what is this empty formality, mister? The void is in your submission is so pronounced void. You are raising an issue without any basis. The petitioner is before this court. The prayer for expediting the CP number 1187 of 2022 in the Court of Learned Judge, Family Court 1, Bhubaneswar. It is submitted that the opposite party is seeking adjournment, and 500 days have passed since her examination in chief.
Examination, close of examination of
Closure of
petitioner.
examination in chief as well as cross examination
Of petitioner. Here.
of the petitioner. The Hon'Ble pointedly asked whether this is the only case pending before the said court where the examination in chief has been completed. Examination in chief as well as cross examination has been completed, and 500 days have passed. Very fairly, it is submitted by the learned counsel for the petitioner that this is not the only case. It is common knowledge that at Bhubaneswar Family Court, there is a large pendency of cases. And one case cannot be singled out to be kept to be pending or grant of adjournment. Further on being asked whether the petitioner herein has moved the court on any particular occasion, objecting to grant of adjournment or drawing to the notice of the learned court in session that the opposite party in the petition, that is wife in the marriage, is seeking unnecessary adjournment. The learned counsel candidly submits that no such petition has ever been moved. This court is not inclined to grant orders, pass orders for expediting trial of any matter at the cost of other litigants and litigation pending before the self-same court. However, the petitioner shall have the liberty to move the court for redressal of his grievances in accordance with law. The petition stands disposed of. Yes, next.
11.
Mr. Vishnu Brata Singh for the petitioner. Yes, Mr.
The petition is challenging order passed in PLA.
Mr. Swarup, you are saying something. Sorry, yes. Or you are appearing here. You are not appearing here. Okay. This is another matter. Yes.
Petition is challenging the order passed in the PLA case number regarding non-granting of interest, pendantine interest on the award amount, my lord. This page 21 of the order, my lord, the court below directed if the award amount not paid within a 30 days, it shall carry interest of 6%. My pair is along.
Look at the letter. Upon the call it suit trial can call any.
That is a
answer. Let us not evade the question. why you did not go for a trial of the suit and final disposal, taking all the contentions, and why you go for the Lok Adalat? And Lok Adalat cannot be challenged. Ketna decision है Supreme Court or High Court रो?
That is a permanent local, it can be challenged.
No, सेटा भी. तारो permanent Lok Adalat challenge can be challenged. Coup provision ना देखा coup decision.
Because it is a
Because no, sir, Mr. Are you listening to the query? Lok Adalat decision cannot be challenged. There is a settled proposition of law. You are distinguishing between a Lok Adalat and a permanent Lok Adalat. What is the decision? Let us not make our discussion empty like this, Mr. Singh.
The court will have direct
Don't make
interest.
my orders vulnerable. On the teeth of Supreme Court order and High Court order, that Lok Adalat order should not be interfered with.
That is
Because you have agreed and signed there. You wanted, say, pendant light interest at the rate of 20%, litigation cost, all those things are points to be argued in a regular trial. But you have agreed and signed that decree. This becomes kind of a double cross situation. Chokki suno khela re apon sepote bhi chokki, epote bhi chokki. Kemti hobo? You, apon Lok Adalat spirit kono, that you walk distance from your colleague, Mr. Sethi will walk a distance. Both of you agree for a settlement. The court gives a finality, authority. Because it's a pending litigation, cannot end up in an agreement. Two parties cannot agree, but they agree for a settlement. That agreement is made a decree of the court. And after that, it is passed. You say that I should be given pendant light interest. And you are saying that permanent Lok Adalat can be interfered with by court. It's a new proposition of law. So I'll dispose of or adjourn. I had learned counsel for the petitioner. The petitioner was the applicant before the learned court, learned permanent Lok Adalat. Khurda at Bhubaneswar, in permanent Lok Adalat, into bracket public, you take your seat. Public utility services, Khurda at Bhubaneswar. The PLA case number 50 of 2021 was disposed of by award dated 9/9/2025. The matter was taken up under the provisions section 22 capital C to bracket 1 of the Legal Services Authority Act, 1987. The petitioner challenging the said award seeks for pendant light interest. Mr. Singh, pendant light interest. Pendant light interest up to the period of payment. However, the learned PLA has directed for payment of 6% interest per annum.
Failing which, if not paid within
for delay in payment of the awarded sum. From the date of award, that is 9/9/2025. Date of award भी कुछ लिखी ना थी actually. अपन actually भूल पड़ी चली. Date of award लिखी ना थी.
No, first within a period, held liable director to pay within a period of 1 month assured amount of 10 lakhs. Under so if in the event of non-compliance of the award, the amount shall carry interest at the rate of 6% annum until final.
अपन add कर देले. From date of this award, the entire period I mean question. That is my understanding.
No, he has stated if payment
बुझो जो नहीं पढ़ू नांते उतरे.
Director to pay
in the event सेटा ऊपर छाड़ दियो.
In the event of non-compliance of the award, the said amount shall carry interest at the rate of 6% annum until final realization by the applicant.
So it can be read that the entire period you have to pay 6% if in case of non-payment.
Non-payment,
Non-payment हेले पूरा period 2 मास भितर न देले पूरा period पे 6% देबे.
1 month.
आपण सेटा को लिखा हैनी कोठी आपण जोडा ऐड करछंती.
ମୁଁ ଖାଲି କହୁଛି
ଶୁଣିଲେ ହବ effectively ସେ ଯୋଉ pendant light ଆପଣ କହୁଛନ୍ତି ସେ second ପାରାରେ ସେଟା ସେ ବି ଦେଇଛନ୍ତି. ଯଦି 2 ମାସରେ ଦେଇଦେବେ ତାହେଲେ
1 month.
ସରି ଯଦି 1 ମାସରେ ଦେଇଦେବେ ତାହେଲେ
no interest.
नो इंटरेस्ट ଯଦି ଦେବେନି କେତେ ଇଣ୍ଟରେଷ୍ଟ କୋଉ ପିରିୟଡରେ ଦେବେ
ସେଟା କେହି ଲେଖିନାହାନ୍ତି until
ତାହେଲେ you agree with me also ଲେଖିନାହାନ୍ତି ମାନେ entire amount will carry that amount.
ସେ they have already paid within a
ତାପରେ ଆପଣଙ୍କର ଏଇ ଯୋଉ ଆୱାର୍ଡଟାରେ ଆପଣଙ୍କର ଡ୍ୟୁ ଡେଟ୍ କୋଉଠୁ ହିସାବରେ କୋଉଠି କୋଉ ପାରାରେ ଫାଇଣ୍ଡିଂ ଅଛି?
The due date is not finding.
ତାହେଲେ କେମିତି ତାହେଲେ
The date of application. My payer is from the date of application.
You have to deliberate or not, or else how we will find the truth? If there is no finding from the due date, then how suppose let us assume that I will entertain that.
Pendant time during pendency of the case, the interest.
Due date pendant like interest due date जानिया दरकार नहीं कोर्ट रो.
No, pendency of the when the case was filed, my lord.
आपण जो भी केस फाइल करो due the amount became due to a particular person.
September 21 फाइल ହେଇଥିଲା case.
That I did not ask you. The amount became due to be paid to you from which date? So सेटा मु डिस्कशन करूची बर्तन आपण संगे. So that is also not apparent from the award. ଆପଣ ଲାଷ୍ଟ ଲାଇନ୍ ଡେଟ୍ ଅଫ୍ ଆୱାର୍ଡ ସେ ଲେଖିନା ଛାଡ଼ି ଦିଅନ୍ତୁ. On being asked, the learned counsel for the petitioner submits that the awards passed by the permanent Lok Adalat can also be challenged. And given some time, he shall give citation, public precedents on the same. It was also brought to the notice of the counsel for the petitioner that the parties agreed before the permanent Lok Adalat for disposal of the matter, and the matter has been taken up under the provisions of Legal Services Authority Act. Therefore, the scope of interference in appeal is not there. The learned counsel seeks and has adjournment. This kebe chahunchandi
27th.
This in the week 27th ag outing niyantu apon should examine korantu. If you come up with a case law that it can be interfered
February 1st
in the week commencing 2/2/2026 ଆପଣଙ୍କର ଏଟା ଏକ୍ଜିକ୍ୟୁସନ ଫାଇଲ କରିନାହାନ୍ତି?
No, they have already paid. Only interest part they have.
That should have been your opening statement. I was thinking that they are not paying it.
No.
That is, I have been discussing also from date that it has not been clarified. All these things. It is on being asked, the learned counsel for the petitioner submits that the award has been satisfied as directed by the learned PLA. Yes, next.
Item 12.
I have filed an application for intervention. For the reason, my lord, I will show to your lordship many things have happened in the meanwhile. I am giving a copy to my learned friend, but this is a 2015 matter, your lordship. In the meanwhile, civil suit filed is dismissed, and there are many more things. Since I am giving a copy just now, I will assist your lordship.
Mahapatra, you are there. So, Diptiranjan Mahapatra for the petitioner. 12. Mr. Prem Kumar Mahanti, AC for the OP1. Mr. Samir Mr. Senior Advocate along with Mr. Palta Singh.
Satyajit Palta Singh.
Mr. Satyajit Palata Singh for OP number 2.
मैं
No, sorry.
interview
OP number 2 पे क्या appear करछन?
OP number 2.
OP number 2 is dead.
He is dead. Your Lordship.
But here there is a
OP number 2 पे blank कर दियो, blank. It is submitted at the bar that the OP number 2 has since passed away and has not been substituted.
no.
Has not been yet substituted.
And there may not be also a case of substitution, which is a trust. Members are there. If a member passes away,
पार्टी करना है
deletion करिपारंती.
ना ना cost title देखो ना पार्टी करना है. You kindly look at the cost title.
Yes, cost title, Your Lordship.
OP2 पार्टी ही ना. ଯଦି ଆପଣ ମାନେ ଆପଣ କହୁଛନ୍ତି OP2 trust ନା OP ନା petitioner trust.
କହୁଛି ଯେ OP2 is a member of the trust.
So ତାଙ୍କୁ ସେ capacity ରେ କରିନାହାନ୍ତି.
Capacity ରେ କରିନାହାନ୍ତି.
ଗଲା ତାହେଲେ ଆପଣ.
ଆଜ୍ଞା.
How the court will interpret that? ସେ ଯଦି ଜ୍ୟୋତିନ୍ଦ୍ରନାଥ ଶର୍ମା ବା trust representative member ଜ୍ୟୋତିନ୍ଦ୍ରନାଥ ଶର୍ମା.
Trust.
Whatever. ତ କରି ତ ନାହାନ୍ତି ଆଉ କଣ କରା.
In the meantime, 2021, there was an amendment Society Registration Act bringing that these disputes are to be decided in the competent civil court. So a suit is also filed. The suit is not being proceeded because of the pendants of the petition that since
assist Your Lordship. ଗୋଟେ petition file କରି
I cannot take up a matter when the OP number 2 has passed away.
ଦ୍ୱିତୀୟ ଜିନିଷ
Recording that, how can I proceed?
ଗୋଟେ ସିଭିଲ ସୁଟ ଡିଗ୍ରୀ ହେଇସାରିଛି ମୁଁ ଇଣ୍ଟରଭେନସନ ଆପ୍ଲିକେସନ ରେ ସେଟା ଗୁନ୍ଥିଛି.
Correct. No, you said
Another
that. I pointed out to Mr. Mahapatra that
another writ petition direction has been issued to dispose of an appeal where the notice is not yet sufficient. से सिविल सूट जो लूज कले गोटे अपील से प्रिफर करछनी. They filed a writ petition making everyone as a party.
Mr. The court has to trust a lawyer. जे कहला से कोर्ट रे आगे डिस्पोज करंतु से कोर्ट कोन कहबे जानचंदी जे
आगे फाइल करछि से मैडम मुडे रिकॉल फाइल कर
सेटा दैट इज पार्ट ऑफ हियर कोन करा जे
आगे नोटिस इज नॉट सफिशिएंट
हैपनिंग आपण लोकल अदालत हैला परे डिसाइड हैला परे डिक्री अवार्ड सैटिस्फाई गेला बटन चैलेंज हैलानी सेटा
तापर सेटा सीएमपी होवा कथा डब्ल्यूपीसी होवा कथा नुहे कैन अरेंजिंग आउट अपील
को आपण जदी मते प्रश्न पचरे
मु प्रश्न नेटा असिस्ट करछि कहि
ऑब्वियसली नहीं सो ऑब्वियसली पार्टली वी आर डेलिबरेटिंग तो बहुत जिंस आगा यू हैव टू कीप क्वाइट एंड आई हैव आल्सो टू कीप क्वाइट और लिख ले दिस स्टेटेड एट द बार बाय द लर्नेड हां सब्स्टिट्यूट ऊपर जो अपीयरेंस सिलेक्शन थी लिखिबे मिस्टर समीर मिश्रा सीनियर एडवोकेट लिखले जोटा फॉर इंटरवेनर वो OP2 डाक देइतिली तापर सब्स्टिट्यूट लिखा हैज नॉट इट बीन सब्स्टिट्यूटेड आईए लिखिबे केते सेटा 18220
माय लॉर्ड
18220 of 2025 the IE has been filed by the intending intervener petitioners.
मैं जो registered society trust है इची तादरे I am one of the member. I was also defendant number 10 in the suit.
Was stated to be a member of the registered society and vitally interested in the subject matter of the present proceeding. Copy of the IE is served on the learned counsel for the petitioner as well as the learned additional standing counsel for number 1.
नहीं लेकिन दिल्ली आपन को 1 को दे दीजिए आगो.
This is height of multitasking. सब जिन सब फटफट कंक्लूड करंतु कौन कहले in court today and has already been served on the learned AC for the OP number 1. The learned counsel for the petitioner seeks time to obtain instruction and file objection if any. How much time is to mark? This सप्ताह पर करते.
First February.
In the week commencing 2/2/2026.
मैं आ गोटे प्रेयर
orders please.
Read petition I have only the petition copy. So गोटे annex सहित गोटे कॉपी टे दियंतु. I don't
आपन को रीड
assist हां.
ए आपन कोर्ट ले जान बेटर अब. The connected writ, the learned counsel, the learned senior advocate submits that copy of the WPC number 14886.
1423
14238.
of
Copy of
2015.
the writ petition 14238 of
2015,
2015,
which is on board.
which is tagged to the 9th of the
This is the writ petition.
This is the writ petition they are
copy of the
pressing.
present writ application.
Yes.
ଆପଣ ଦେଇଦିଅନ୍ତୁ ଗୋଟେ
यही writ.
ଠିକ ଅଛି the copy that he shall obtain a copy of the 1/4 he may be granted leave to obtain copy of the writ petition, the present writ application from the registry of the court. Copy जो लिख लेंगे public soft copy. Leave granted, the registry shall provide copy of the writ petition, copy oblique soft copy of the writ petition as per rules. Yes, next.
13.
My lord, on behalf of D. Tripathi, I am appearing for the petitioner.
What's your name, sir?
Hitesh Kumar Sahoo.
J. Sahu.
Hitesh Kumar Sahoo.
Hitesh. So H. Sahu on behalf of Devasith Tripathi for the petitioner. Opposite
lord,
party none. The office note put up by the registry indicates that notice and admission and stay issued to the OP number, sole OP, has been returned undelivered. The learned counsel for the petitioner shall obtain instruction list after କେତେ ଦିନ ନେବେ instruction ପାଇଁ
15 days.
2 weeks ପରେ ଦିଅନ୍ତୁ. List for orders in the week commencing 2/2/2026.
Yes.
Call କରନ୍ତୁ ଆପଣ.
14.
Mr. Sujoy Shankar Singh Dev for the petitioner, opposite party blank. The learned counsel for the petitioner at the beginning of the proceeding mentioned the matter. He is present at the virtual court, High Court of Orissa, Kolahandi at Bhavani Patna. Para. The learned counsel seeks and has 2 weeks time, further 2 weeks time to remove the defects as pointed by SR. List in the week commencing, list for orders in the week commencing 2/2/2026. Yes, next.
15.
Yes, Mr. Behra, defect.
That's my lord.
Copy file ही नहीं.
Copy is a private party.
A copy of the trial court just bent. About the court fee ଦେଇନାହାନ୍ତି. ସେଟା ତ condonable ହବନି. Mr. Behra, learned counsel submits that he shall remove the defects as pointed in SR within 5 working days. Na se besi. ଟଙ୍କା 10 ପଇସା. Degree by ଟଙ୍କା 10 ପଇସା ଦେଇନା. Within 5 working days. List କେବେ ଚାହୁଁଛନ୍ତି?
27.
List in the week commencing 27 1/20/26. Yes, next.
16.
Please, Your Lord, on behalf of Sunil Kumar Panda.
Yes, please.
My lord, in this I have
Defect same 4A. Decree ରେ ଟଙ୍କା 10 ପଇସା ଦେବା କଥା ଦେଇନା.
Sure,
Same order. पण କେବେ ଚାହୁଁଛନ୍ତି 27 ତାରିଖ?
as you please, ma'am.
No, I don't have a date as you please. I have been looking at. That's with
I have no instruction on the next adjournment date, my lord. So kindly appropriate.
ଆପଣଙ୍କ ନାଁ କଣ?
Sir, Dakshesh Darshan Naik.
Mr. D.D. Naik, you are writing.
Yes.
So D.D. Naik on behalf of SK Fonda for the petitioner. Opposite party kehi nahanti. Opposite party none. The learned counsel for the petitioner seeks and has adjournment to remove the defects within 5 working days. 7 working days for them. List in the week, list for orders in the week commencing
27.
27/1/2026.
Or blank?
Yes, next.
17.
May I please your lordship? Lordship, I am challenging the order dated 19/4/22.
Notice check to
Notice
return.
already solved, lordship, but no one is appeal for the opposite party.
केम जानले सॉल्व होला बोले केम जानले आपण
Lordship, it's showing in the noting, lordship.
कोडा पढले
Lordship, in the High Court noting, lordship.
पढू नांदी
I don't bring that.
अरे what is this sir अरे look at the paperless also it is provided for you only
Yes, sir. Affidavit filed by the petitioner at I number 2 of 23 for stay notice on admission and stay issued to the R1 and 2. It did not return in this regard tracking report including item delivery at Hon'Ble at flat rate.
so it did not return hele कोन हबो
So it is not returned.
हां it return hele कोन हबो अरे is it that I will be so conscious that every time I will read the brief also suppose I trust and pass a order
Well, I am appearing on VC on behalf of the respondent.
he did not mark you though I did mark you he did not mark
Lordship, under the instruction I am appearing today, Lordship, I may be granted 1 day time to file the Wakalatnama, Your Lordship. But due to some health issues, I could not come.
Sisir Panigrahi.
Mr. Sisir Panigrahi for the petitioner
Lordship, may I prepare one more thing, Lordship? I filed a stay, I for Lordship for stay of the entry maintenance, Lordship.
that cannot be stayed you deposit the entire amount here if you want stay for money decree this is a money decree which chapter of CPC deals with money decree
Lordship?
Which chapter of CPC deals with money decree?
Money decree. Money decree, it's about, Lordship, maybe order out rule 21, rule 21, order 21, rule 99, something.
Maybe that is not the order. But you read it. When you are seeking a stay, what is the condition to grant a stay in case of a money decree? You have to secure the decree.
Yes, Lordship.
Have you secured it?
No, Lordship, they are not filing the execution, Lordship. They are not even filed the execution.
You want them to file execution. You make them prayer before them. Why have come to court? Court cannot direct them to file execution.
No, Lordship, they are not filing the execution. And the area of monies are increasing, Lordship, because of that.
Sorry?
I say, Lordship, they are not filed the execution in the
why can this grant a stay because they have not filed execution? The decree is stayed.
No, Lordship,
that is not
increasing, Lordship, because of
so make a legally nuanced submission. It is not a drawing room casual discussion over a cup of coffee. That we do not know what order the court doesn't know what it is dealing with. Please appreciate that. I can't pass such orders. That since they have not filed execution, the decree is stayed. Since there is no secure, the decree is not secured, so it has to be stayed. CPC then?
CPC.
You said 21, it is correct. Execution of decrees and orders. Order 41, Rule 5, stay by appellate court. 6 security in case of order for execution of decree appealed from. The court has to secure the decree.
Yes, sir.
So when you are filing appeal, you have to look at order 41. Apart from 21, you have to look at 41.
Yes, Lord. So this is the problem for topic.
So Sisira Panigrahi for the petitioner. The petitioner husband is before this court challenging the judgment dated 29/1/2020 passed in CP number 116 of 2018. ଆପଣ 125 CRP ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ନାଇଁ?
Lordship, order dated 19/2029.
ମୁଁ ଭୁଲ ଦେଖୁଛି ନାଇଁ କି?
Yes, your lordship.
So I have opened a wrong brief actually. In the paperless, I have opened a wrong.
17.
Item 70. उन्नीस 4/22 कौन देखले? पेज कितने?
Lordship, page number 28. Page number 27, Lordship. Yes, CRP number 90 of 2018.
Annexer?
Annexer 1, your lordship.
Page 14.
Page number 27, lordship. Running page number 15.
Judgment or first page?
Yes, lordship. Is the order lordship, maintenance order, the CRP number 90 of 2018.
Page.
Yes, your lordship. Page number 27, running page number 15, lordship.
Case number?
Case number, lordship, CRP 90 of 2018, 90 of 2018.
ଆପଣ କୋଉ ବ୍ରିଫ ଧରିଛନ୍ତି ଦେଖିବେ? ଆପଣ ବ୍ରିଫ ବୋଧେ ଆଉ ଗୋଟେ କଣ ଧରିଛନ୍ତି?
Yes, lordship.
ଆପଣଙ୍କର ଏଇ ଯୋଉ RPFM ଇଏ
Yes, lordship.
ଆପଣ RPFM ରେ ଦେଖନ୍ତୁ it starts with page 13. ଆପଣ 27 କହୁଛନ୍ତି?
It's order.
अरे I believe you मते देखिया ପାଇଁ कहूनी बट आपण भी देखि परिबे मु जोडा देखुची I am looking at that. Why should I doubt you दे आपण मते सीधा annexer 1 स्क्रॉल करंतु नि सीधा टच करंतु बुकमार्क रे annexer 1. पेज कितने?
Please. Answer one is comes from the page number 27. I am so the order number, lordship. It's come from the
order first page टा पचरुची को पेज रे अछि आय
Annexer 1, lordship, 13 or 28.
और आपण को मु पचरुची फर्स्ट पेज 13 ठीक तो मु ठीक देखुची तो तले आपण 27 27 चले चलते तो
order टा
judgment dated 19/4/2022 passed by the Lord Judge Family Court Puri in CRP number 90 of 2018. So by the said judgment, the petition filed by the respondent, the opposite party, the wife in the marriage under section 125 CRPC, being the petitioner as well as the minor daughter represented through her, was allowed. It is stated that the said judgment and decree has not yet been satisfied. ना करछन किछि पैसा दैछन
ये लट से पैसा देइछे बट अकाउंट ट्रांजैक्शन अछि 2,35,000 टाइम देइछे
सेतरे
नो लॉट्स से अलगा पैसा माने एमते नै
अलगा कोन
से एग्जीक्यूशन फाइल करना
Mr. with greatest of respect Mr. Paningre, let us talk law here. Have you satisfied that decree?
Lordship, they are not filed execution, lordship. So
no, they are not required to file execution. On being asked whether the
yes, lordship, I provide some money of 2 lakh.
Debtor petitioner has satisfied the decree. Repeatedly, it is answered by the Lord Counsel that no execution has been filed. In considered opinion of this court, for satisfaction of the decree, execution need not be filed. Whereas, in case of non-satisfaction only, execution has to be filed and for enforcement of the decree. Apparently, for the last more than 3 years, in the past, for about 4 years, the decree remains unsatisfied. Yes, what next? I'll dismiss it today.
Lordship, can we fix it next date?
No. 3 years is enough, sir. This is 23 matters. We are in 26.
Lordship, I already paid Lordship 2,25,00,000 rupees.
6 lakhs for pendency, and these are the reasons for pendency.
Lordship, idiot's money is Lordship 6 lakhs.
Sir, I do not know. I'm not.
No, Lordship, I'm coming to the point, Lordship.
Sir, the question is, have you satisfied the decree? The answer is no. So that's the then what next?
Lordship, I am not satisfied with that order, Lordship.
So you should have secured here on the date you filed the appeal. On 24/11/2022, you should have taken steps for satisfaction, securing the
within
decree.
that period limit, Lordship, opposite party number 1 is staying with me and take
Sir,
more.
ସେଇଟା ଆପଣଙ୍କର ଯୋଉ staying with me ଟା କୋଉଠୁ ପାଇଲେ? କୋଉ ସୁପ୍ରିମ କୋର୍ଟ ଡିସିଜନ ଅଛି? If the opposite party in the decree,
No, Lordship, I am saying
then why you are saying
Indian money is to be excluded for that period.
we are not discussing who is staying with whom.
No,
If you are
I am
not
saying that,
satisfied the
Lordship,
decree and you have preferred to challenge, you have not secured it, then what the court will do?
Lordship,
The court,
that period-
the petitioner has 1 week time to secure the decree for moving the petition in form of appeal before the appellate court. How much time you require to secure the decree? You could have done that, deposited here. You do not like to pay someone. What you will do?
Yes,
You deposit before the appellate court.
Lordship, that is the area. Since the application is filed before the learned court is 2018, Lordship, and now
Sir,
it's
please don't state the obvious. I have already dictated.
yes, your Lordship.
So whether you will satisfy the decree, by what time you will
we
secure the
already
decree?
given your Lordship 2 to 4 lakhs rupees, Lordship.
4 lakhs or 40 lakhs, I am not asking you. By what time you will secure the decree before the appeal to be considered?
Lordship,
Do you understand what is securing a decree and paying the amount?
yes, your Lordship.
Yes. So you are so
2 weeks time, Lordship.
Yes. Talking about that. How much time will it take to deposit the amount here?
2 weeks time, Lordship.
Well, like, has though this court is not inclined to grant further time, as the matter was taken up on 24/11/2022, and the petitioner is yet to secure the decree, on being persuaded by the learned counsel, the petitioner has further 3 weeks time to secure the decree before this court for the petition in appeal. For the RPFM to be taken up. Secure the decree in terms of order XLI 40 order 41. Rule 5, 6 and 8. The office note put up by the registry indicates that notice on admission and stay issued to respondents 1 and 2. They did not return. The postal tracking report shows that the item delivered at Boromunda Colony, SO. It is submitted by the learned counsel, Mr. Satyaprakash Satapathy, that he has instructions to appear on behalf of the OP number 1, mother, and OP number 2, minor child, represented through OP number 1. He seeks how much time to file Wakalatnama?
Around 1 day time. By tomorrow I'll file.
He seeks 3 days time. He submits that he shall file Wakalatnama within 3 working days. The matter shall be listed on in the week commencing 9 February 2026 by the said date, by the next date, petitioner shall secure the decree before this court by making the deposit of the decretal amount in area till date for taking up of the RPFM pending since last about 4 years. Yes. You have been granted sufficient time.
Yes,
So after 4 years, we will be taking up the matter.
marriage is also deserves.
Marriage deserve. ସେଥିରେ ଯଦି ଆପଣ ଦେଇଥିବେ ଯଦି କହୁଛନ୍ତି ଆପଣ ଯେତେବେଳେ ସବମିଶନ କରୁଛନ୍ତି be clear in your submission. ଆପଣ RPFM ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି?
Yes, your lordship.
ଆପଣ ଯଦି permanent alimony ଦେଇଛନ୍ତି?
Permanent alimony पे किसी decree रे किसी mention नଥିଲା lordship.
So that still worse. That is the argument against you. So because I am trying to assist you also partly. Yes.
65 to delay.
Mr. Suresh, the appellant, the petitioner wife is before this court challenging the judgment dated 29/10/2022 passed by the learned judge, Family Court, Jajpur, in CRP number 102 of 2019. Stop. By the said judgment, the petition filed by the wife and the minor child and her minor child under section 1 to 125 of CRPC into brackets in Sheffield was allowed to the extent rupees 1,500 to be paid by the opposite party husband towards the petitioner and 800 to the minor child. The petitioners are before this court for enhancement of the amount granted. So, issue notice along with this order in the IA as well as the appeal. ऊपर IA appeal लिख देंगे. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5
days.
Five working days. List after is sir, liberty to mention. During pendency of the present petition, the petitioners shall have the liberty to receive the amount awarded by the judgment dated 29/10/2022 passed by the learned judge, Family Court, Jajpur, in criminal proceeding number 102 of 2019 without prejudice to their rights and contentions in the present petition.
Well,
yes, next.
19.
और करिए ना कौन करिए? अच्छा, लगते वक्त yes.
20. I am appearing. I have already appeared.
Petitioner Nanti.
Much. Petitioner consent appear.
Achha. Mr. Mishra along with Mr. Siva Shankar joining. Yes, madam.
I am appearing for OP number 9. Your lordship.
What best can be done?
PRPC for transfer of 2 civil suits, one at Puri, one at Cuttack. Applicant is
Siddharth Mishra, learned counsel, submits that he has instructions to appear along with the learned counsel for the petitioner.
I have already appeared.
He has already filed his appearance memo. Name of Mr. Mishra shall be reflected in the court list as well as the case brief from the next listing. Ms. Pratima Patra.
Yes, Sulochana.
I'm sorry. Sulochana Patra, learned counsel, submits that she has instructions to appear along with Mr. H.K. Rath Singh. Name of the Wakalatnama and she files Wakalatnama today. And she shall file Wakalatnama in the registry today. The Wakalatnama shall be taken on record, scanned copy be updated. Name of Miss Patra, Mr. H.K. Rath Singh, learned counsel and associates shall be reflected in the cause list as well as the case brief as the counsel appearing for the opposite party. Upon instruction कौन अच्छी?
Copy number 9 units.
खाली 9 पे अपना फिर पूछो. खाली दो. Copy number 9 नहीं. अन्य sufficient है नहीं.
गोटे चिट्ठी कोर्ट हाई कोर्ट मागिथिले गोटे रिपोर्ट टा आछि आपन टिके देखंतु. ओपी नंबर 1 ऊपर को जो नोटिस जाइतला से बाबत रे
आपण ओपिनियन लिखिछन. मैडम को फेरी दियो. से फाइल करिवे तापर स्कैन नहीं आसीओ. केते फ्लैग रे अछि मिस्टर मिश्रा?
आया
तुटा रिपोर्ट टा कोचंती. कैन यू टेल द फ्लैग नंबर? Flag F. You can see that. ठीक देख पारे. मैडम you can see.
मते तो जणा नहीं.
से को आपण अथली जानते आपण. तो मेरे आपण देखनंती.
बरस
Flag F.
आपण सुविधा देइ छते आमे नहीं पारु.
आपण पे रखाई छै. This is the future.
से मु बुझु छी आमे नहीं पारु.
आपण खाली हाथ रे आसीबे. ଆଉ କୋର୍ଟ କୁ ଆସିବେନି କାଗଜ ପତ୍ର ଧରି
ସାଙ୍ଗରେ ଜଣକୁ
ଯାହା ପାଉଛି ନେଇକି ଯିବେ.
ऑर्डर ହେଇଥିଲା
ସେ ଆପିୟର ହେଇନାହାନ୍ତି.
ନାଇଁ
ସେଠି ଆପିୟର କରିନାହାନ୍ତି ଆଉ. So the court thought that since he is appearing there, so they
yes,
but say appear करनाहांती अब. But the learned civil judge senior division has taken steps for service at Bhubaneswar. So he has sent the notice to Bhubaneswar also. It is not a technical. Opposite parties karibe. Opinion number 9 singular. The learned counsel Mr. Mishra submits that earlier order dated 14/11/2025 was passed by the coordinate bench, observing that notice may be served through the learned civil judge senior division Puri in the pending CS number 324 of 2025. In response, the learned civil judge senior division has forwarded instructions to the registry of this court, which indicates that the defendant number 1 in the CS case, in the same CS case, Mr. Mishra is the same person. Here as OP1, who also is added as OP number 1 in the present case, has not entered appearance before the learned civil judge senior division pool in the CS. It has been further indicated by the learned civil judge that the notices have been forwarded to the JIC, Judge in Charge, Nijarat, Bhubaneswar, by letter dated 11/12/2025, with respect to with a request to communicate the notice to the defendant number 1, who is appearing in the CS 324 of 2025 before the learned civil judge senior division. Awaiting sufficiency of notice, how much time? It will take some more time.
Sir.
4 weeks.
Sir.
Awaiting sufficiency of notice on the other opposite parties. ଆପଣ ଖାଲି ନାଇଁ ନା ଆପଣ ଅନ୍ୟମାନେ ପାଇଁ appear କରୁନାହାନ୍ତି?
I will take instruction.
Instruction ନିଅନ୍ତୁ. But obviously, I mean, court cannot compel, but
in this case, your
but the
lordship.
thing is that this goes on like this. On the other opposite parties, the matter stands adjourned to be listed in the week commencing 9/2. 16/2/2026.
Interim order ଥିଲା
Interim order as passed.
permit କରିଥିଲେ
11/9.
ଆଜ୍ଞା interim order କରିଥିଲେ ସେଠି adjournment ଦେଲେ ସେ allow କରିବେ ହାଇକୋର୍ଟ କର order
Date.
that is
14/11.
ଆଜ୍ଞା initial first order
Para 9 of order date order number 2. It is made clear that if such an application is moved, learned court below shall do well to adjourn the proceeding in CS.
ଆଜ୍ଞା
Eta. The interim order as directed by the coordinate bench by order dated 14/11/2025 shall continue till the next date of hearing. Rest of the matters after recess, any mention or adjournments he will give you.
Pardon, my lord. Item 29. I am for the petitioner. So,
adjourn କରିଦେଲେ ନା କଣ?
Arjun ଆଜ୍ଞା ମତେ ଅବଜେକ୍ଟ କରୁଛନ୍ତି ସେଟା ଟିକେ ସର୍ଟ କରନ୍ତୁ ସର୍ଟ ଡେଟ୍ ଟିକେ କଲେ ବିକଜ କାଉଣ୍ଟର
ଆପଣଙ୍କର ଦେଖନ୍ତୁ ସାର୍ ଆଫ୍ଟର ନୋଟିସ୍ ମ୍ୟାଟର ତ ଯାହାହେଲେ ବି ଟିକେ ଟାଇମ ପରେ ରହିବ ନା ଆରମ୍ଭରୁ ରହିବ ପ୍ରେସ୍ ଆଡମିସନ ତାପରେ ଅର୍ଡର୍ସ ଏବେ ଓଲ୍ଡ ମ୍ୟାଟର ଗୋଟେ ଆସୁଛି
ସାର୍
ସୋ ଟିକେ ୟୁ ଅଲସୋ ପ୍ଲିଜ ଆଡଜଷ୍ଟ ଟିକେ
ଠିକ ଅଛି ସାର୍ ଟିକେ
give some player join to the listing.
I was supporting that.
23 ରେ ତ ଆସିବ ଆଉ କଣ?
Last week of February
Last week ରେ ଗୁଡେ ମ୍ୟାଟର ରଖିଦେଲେନି ସାର୍
এটা lifting of
and now in fact now also I am accepting adjournment of press admissions also. The adjournment ବଢି ଯାଉଛି 23 ଆପଣଙ୍କର 25 ମସିହାର କେସ୍
ସେଟା procurement of paddy crops in meantime already counter filed by the government ତାଙ୍କର ରୋଡ କିଛି ନାହିଁ
ଆଚାର୍ଯ୍ୟ କୁଆଡେ ଗଲେ
ମୁଁ ତାଙ୍କୁ କହିଦେଇଛି ମୁଁ
କେବେ
ଫାର୍ଷ୍ଟ ୱିକ୍ ଅଫ ଫେବୃଆରୀ ରଖନ୍ତୁ
ଆଇଟମ 39 ଟା 2 ୱିକ୍ କମିଂ 2 ନା 9/2 କେବେ ଚାହୁଁଛନ୍ତି ତ ମହାନ୍ତି ଆଲୋକ ମହାନ୍ତି
ସେଟା 22 ଯାଇଛି 22 କୁ ଯାଇଛି
ସେ ଚାହୁଁଛନ୍ତି ଜଲ୍ଦି କେବେ କରିବେ
9/2 କର
9/2 ୱିକ୍ କମିଂ 9/2 କରିବେ ସେ
Item 22, my lord.
order has not been passed. Simple adjournment is there. Rejoinder କିଏ ଫାଇଲ କରୁଛନ୍ତି ଆପଣ ନେଇଥିଲେ ଟାଇମ ମହାନ୍ତି ଆଲୋକ ମହାନ୍ତି
I have not taken time. They have file counter. I will file rejoin in meantime 9/2 ଅଛି ଫାଇଲ କରିଦେବି
ତାହେଲେ ସେଟା ଅର୍ଡର ଲିକ୍ୱିଡ କରିବାକୁ
Item 22, my lord.
wherever any learned counsel both are present and seek any date he will give you the date.
Yes.
Madam, item 22.
Yes you want adjournment.
Yes, madam. Just short adjournment.
ତାହେଲେ ସେ ରିଚ୍ କରୁ ତ ଅଛନ୍ତି ପଢିଯିବ ଆମେ କୋଉ ଯାଇ ଆମେ ତ ଗଲେଣି already we have reached 21 20 ଯାଇ ଗଲେ ତ any difficulty you instruct any of your colleagues to remain present.
Item 23 both the sides are there. This is for disposal.
23
Matrimonial appeal.
Yes. 23 MATA କଣ jurisdiction ଅଛି
এটা সিঙ্গেল জজ মাটা
single judge matter special matter okay তাহলে 23 টা ডেট নেই দেই পারি
আজ্ঞା
whichever matter the learned counsel are seeking dates please you will give it no difficult
we are both present
yes you take a date
Pardon, my lord. Item 22, 27 तारीख adjournment. ମାନେ 1 week time man.
ঠিক আছে ଆପଣ କହିଦେବେ
27 तारीख.
I trust you sir ଆପଣ କହିଲେ ସେ ଲେଖିଦେବେ just give him some space तो ଗୋଟେ particular date କହିଲେ it may be difficult
Opposite party.
ঠিক ଅଛି ଆପଣ ସେ କରିଦେବେ
ଆଜ୍ଞା problem.
ଆପଣଙ୍କ ଏଟା କେତେ item 23 କହିଲେ
22.
22 କେ ବେହେରା ମିଷ୍ଟର ବିଜୟ କୁମାର ପରିଡା
Yes, sir.
ঠিক ଅଛି
ଆମଟା 23 होला
ଆଜ୍ଞା ଆପଣ କହିବି କହିଦେବେ
ନାଇଁ
Problem.
Passover code actually डाकिले
Passover after 9
sorry yes
Recording in progress.
That matter not assigned to renewable values.
the order has to be passed 39 ଯଦି କହୁଛନ୍ତି
Again, the paddy
so I have to take up the matter and pass a judicial order so but that has been adjourned 39 ଆପଣଙ୍କର you are Mr.
Mr. Swami, I am submitting on behalf of Mr. Mohant.
Shalok Mahanti ସେଟା ଆର୍ଜନ ହେଇଛି 9/2 ରେ କରିବେ ଆଉ ମିଷ୍ଟର ମହାନ୍ତି ଆକ୍ଚୁଆଲି ଆର୍ଜନ କରିଦେଇଛନ୍ତି ତାକୁ
ପ୍ୟାଡି ପ୍ରୋକ୍ୟୁରମେଣ୍ଟ ଟା ତ ତେଣୁ ଲାଷ୍ଟ କରିଦେଲେ
ଏସ୍ଆର୍ ଆଚାର୍ଯ୍ୟ ଆଲୋକ ମହାନ୍ତି ଥିଲେ ଆପଣ କହୁଛନ୍ତି ନାହାନ୍ତି ବୋଲି
ଏଗ୍ରିକଲଚର ପ୍ରଡ୍ୟୁସ ମାର୍କେଟିଂ ରେ ଏଗ୍ରିକଲଚର ପ୍ରଡ୍ୟୁସର୍ସ ମାର୍କେଟିଂ ଏଟା କମ୍ପାନୀ ରେଜିଷ୍ଟ୍ରେସନ ଆକ୍ଟ ରେ ଆସିଛି ସରି સોસાયટી રજિસ્ટ્રેશન એક્ટ
essential commodities OPDS
ସେନ୍ସେଲ କମିଟି
ନେକ୍ସଟ ଡେଟ୍ ରେ କରିବେ ଆଉ ଆରେ ସେମିତି କଲେ ସାର୍ କେମିତି ହବ ସାର୍ ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି ବୋଧେ ଆଲୋକ ମହାନ୍ତି ଥରେ ଆର୍ଜନ କଲା ପରେ ଆପଣ ଆଉ ଥରେ କହୁଛନ୍ତି ଆଲୋକ ମହାନ୍ତି ଚାହୁଁଛନ୍ତି ମ୍ୟାଟରଟା ଯାଉ ବୋଲି ଦିଟା କଥା ମୁଁ କେମିତି କରିବି ଆପଣ ଆଲୋକ ମହାନ୍ତିଙ୍କୁ ଆଣନ୍ତୁ ସେ ବୁଝିପାରିବେ ଆଲୋକ ମହାନ୍ତି କଣ କହିଲେ ଆପଣ ବୋଧେ କହିନାହାନ୍ତି ଆଲୋକ ମହାନ୍ତି ଆର୍ଜନ କରିଦେଲେ ଅପୋଜିଟ ପାର୍ଟି ପ୍ରଥମେ ଆସିଲେ ଅପୋଜିଟ ପାର୍ଟି ଆର୍ଜନ କଲେ ତାପରେ ଆଲୋକ ମହାନ୍ତି ଆସିଲେ ରାଇଜ କଲା ପୂର୍ବରୁ ସେ ମେନସନ କଲେ ଯେ ଏଟା ଆର୍ଜନ ହେଇଯିବ ବୋଲି କିନ୍ତୁ ଘଣ୍ଟେ ପରେ ଆପଣ କହିଲେ ଯେ ଏଟା ନାହିଁ ବୋଲି ଡିଟରମିନେସନରେ ଦିଟା କଥା କେମିତି ହବ ସେ ତାକୁ ସେ 3 ଥର ଗୋଟେ ମ୍ୟାଟର କଣ ମେନସନ କଲେ ହବ ତ ଆର୍ଜନମେଣ୍ଟ ଥାଉ ତାକୁ ଆପଣ ଯଦି ଅନ୍ୟଟି ମୁଭ କରିବେ କଣ ଅଛି ମୁଭ କରିଲେ କିଛି ବାରଣ ନାହିଁ ସେଟା 9/2 ରେ କିଛି ଅର୍ଡର ଲେଖନ୍ତୁନି ସିମ୍ପଲି ଆର୍ଜନ କରିଦିଅନ୍ତୁ ସୋ ଦ୍ୟାଟ ସେ ଚାହିଁବେ ତାଙ୍କୁ କଣ କରିବେ ଆଉ ଯଦି ଆଟଲିଷ୍ଟ ୟୁ ସୁଡ୍ ହାଭ ଦ କର୍ଟିସି ଯିଏ ଯୋଉଟା କହୁଛନ୍ତି ସେଟା ଯଦି ଆଉ ଥରେ ବଦଳଉଛନ୍ତି ସେ ତ ଆସିବେ ନା
So nine, but can it be taken up as last skip?
Yes.
Because the time is. See,
so let us see. Let us proceed with the list. Yes. ପାସଓଭର ଯାଉ ଆଗ
ଡାକିଲେ ତ ସେଇଥିପାଇଁ ମୁଁ କହିଲି ଆଜି
ଲାଇନଟା ଡାକିଲି ପାସଓଭର
ମୁଁ ସେଥିପାଇଁ କହୁଛି ଆଜି
ଲାଇନଟା ପାସଓଭର ହେଇନି ସେଟା ସେ ଭୁଲ ବୁଝିଛନ୍ତି ଠିକ ଅଛି ଲାଇନଟା ସାର୍ ମେନସନ କଲେ ଆପଣ ଟେକ୍ ଅପ୍ କରିବେ ଡାକିଲେ ଠିକ ଅଛି
98
passover non appears for the petitioner though the non appears for the petitioner opposite party blank non appears for the petitioner though the matter is called twice over to grant further opportunity list date jaldi karantu di
2
list in the week commencing 2/2/20 yes next
item 21
Mr. Sangram Jena for the petitioner. Mr. P.K. Mahapatra on behalf of K.K. Swami for the 21. Mr. Sahoo, you are there. Mr. Mahanti. For state. Mr. P.K. Sahoo, additional government advocate.
Standing counsel.
Additional standing counsel for opposite parties 1, 2 to 4. Mr. P.K. Mahapatra on behalf of K.K. Swami. देखिए लिख देना वकालतनामा लिख देना The learned counsel for the appearing parties seek for the time to advance arguments as spread for list on in the week commencing 27/1/2026. Interim order passed earlier shall continue till the next date of hearing.
item 22
So A.K. Behra for the petitioner, Mr. B.K. Polda for the opposite party. The parties seek adjournment to advance arguments as spread for list on 22/2/2026.
item 23
The week date କରିଛନ୍ତି 22/2 item 22 ଟା କେବେ ଗଲା
22 ଟା week commencing 27/2/2026
अच्छा मु आवडे भूल रहे सो वीक कमेंसिंग 27/1/2026
Item 23.
मिस्टर कौन कहते बोटे Mr. Yes, Mr. Samir, Mr. Senior Advocate, along with Mr. Palta Singh for the appellate, Mr. Subhendu Kora for the respondent. The matter is listed for admission hearing. The matter is listed for admission hearing. The counsels of the parties seek further time to advance arguments. Date के बेकर please.
We commencing 9/2/26.
Okay. According to the matter shall be listed in the week commencing 9/2/2026.
Item 24.
But I am appealing for the petitioner through virtual court Bhubaneswar.
Yes.
I have filed interlocutory application because interim maintenance order has been stayed. I am not getting any maintenance. For that reason, Your Lordship, I have filed this interlocutory application. But frankly speaking, copy has not been sought because my friend stays at Bhubaneswar. So that's the problem. Copy of this interlocutory application.
Mr. Das, your matters are coming up regularly here. How you are receiving? Learned associate is there or?
Yes, Lordship. Yes, my associate Sushant Sahoo is there. He will receive the copy from the
Mr. Sushanta Das for the petitioner, Mr. Sanjeev Mahanti for the opposite party. The learned counsel, Mr. Das, being present at the virtual court, High Court of Orissa. Bhubaneswar addresses arguments. It is submitted by Mr. Mahanti, learned counsel for the opposite party, that he has filed IA 357 of 2025. Seeking appropriate relief for vacation of interim order as the grant of maintenance 125.
My Lord, 125.
Grant of maintenance in a proceeding under 161 under section S.125 CRPC into bracket since repealed has been stayed. A copy of the said application shall be received by the learned counsel, Mr. S.S. Sahoo, on behalf of the petitioner within 2 days.
Orders are next week in orders.
Okay. The matter shall be listed for orders in the week commencing
26.
26 or 26. Yes, next.
May please.
Mr. J.K. Digal for the petitioner.
Petitioner.
My Lord, I have a limited till interim order or maybe continue till the
Interim order as passed earlier.
Yes, Lordship.
I'll continue till the next date.
Obliged, Lordship.
My Lord, this is the pensionary benefit. Pensioner.
So
my Lord.
The opposite party, have you checked that it's a 24 matter? Now you are in 26.
No, my Lord. This is the order passed in, my Lord, 25/11/2022, my Lord, in read petition, my Lord. Thereafter, my Lord, first contempt.
Have you heard me what I'm saying? What I said?
This is 24 and the matter regarding this is 24.
Is it not 24? Or I am holding a wrong brief or you are holding a wrong brief? 1645 of 2024.
1645/24, my Lord.
Our discussion has a context. Let us make it that empty and don't, without following what the court is saying, don't start answering. Did I ask that when the matter was disposed of? I did not. My question has some relevance. We are discussing something. In 24, whoever was the DEO, is he still continue as the DEO or it's a different person? It's a quasi-criminal proceeding. Impletion of wrong party is fatal to the petition. Fatal to the order.
In my instruction.
Second aspect is that in case of CO content, notice has to be, the copy has to be served on the other side also. Copy of the order. You have to allege non-compliance, deliberate non-compliance. those aspects, I mean, that is a broader aspect, but this is a fundamental thing. You have to array the party with because it's official capacity. It can't be the individual capacity. So are you sure that the same person is continuing after 2 years?
In my instruction, my lord, same person is continuing.
When did you receive that instruction? Because you filed the application in 24.
24 is the, my lord, contempt proceeding, my lord. In read petition, my lord.
Sir, not read petition, sir. Read petition, an individual cannot be a party.
Yes.
The Lord Counsel for the petitioner has adjournment to verify whether the opposite party is still the present incumbent of the office as indicated in the petition. The Lord Additional Standing Counsel shall obtain instruction regarding compliance of the order.
Here, may I say, my lord, writ appeal is pending against this order, my lord.
So you obtain that instruction, whatever you get, you obtain
That
stay.
we filed the second so-called reply, my lord. We have stated that writ appeal is pending.
Pendency of a writ appeal is not a ground to
This has been
defer the-
issued. This is a case where conviction is there. Now he is praying for provisional pension, which is beyond the scope of the law, my lord. Even though there is a
Conviction?
Yes, there is a conviction. After conviction, if prayer was allowed,
forfeiture of pension.
that provisional pension, that was the subject matter in challenge, and he has been issued with notice. So he is required to contest and dispose of law. You
Yes, Mr. Digal, have you examined any case law on this? That after conviction in a criminal matter,
One order,
sir, I need to complete. We never discussed last night or today morning what I will tell to you. Have you examined the law on this? That whenever a government servant is convicted of an offence and the offence is, the conviction is not stayed, only the punishment is stayed, then what would happen? If, because the consequences,
submission, my lord.
you are not listening, that's the problem. If you know what I am telling you, then you tell me. I have no difficulty to listening you. Next question ta kon? Next aspect ta kon?
In my humble submission, my lord.
अरे ମୁଁ जोटा पचारुଛି humble submission केमती आपनकर हबो submission टा करंतु जदी हाईकोर्ट कले जडे लोक कन्विक्ट हैला परे से जे ताको पेंशन प्रोविजनल पेंशन दियो किंतु रूल रे अछि देई परिबेनी बोली को रूल रे अछि
पेंशन रूल 7 रे
तो आपण जानचंदी ताले
तो सर
I mean that is happening. So rule 7 रे जदी contrary to order pass हैला हाई कोर्ट कले कि सुप्रीम कोर्ट कले सेटा चैलेंज हबो सॉरी हाई कोर्ट कले चैलेंज हैला सेटा
रीट पिटिशन अपील रे रीट अपील रे that order has not been stayed, my lord.
It need not be stayed.
So that
now the content, because that order has not been passed by me, so I have to look at that process. I have to handle that submission or not.
Only
forfeiture of past service रे कौन होबो
सर गोटे आपण पास करंतो
नहीं नहीं मु अगर किछि पास करि परिबिनी दैट्स अनदर थिंग आपण सुनु नांती बोली सेटा प्रॉब्लम होची हैव यू गॉट एनी डिसीजन ऑन दिस जे कन्विक्शन पर पेंशन हाई कोर्ट करि परिबे बोली सुप्रीम कोर्ट डिसीजन सेटा से तो पचेबे आई एम स्ट्रगलिंग यू आर नॉट अलाउइंग मी टू कंप्लीट द सेंटेंस हैज द कोर्ट रिलाइड ऑन एनी सुप्रीम कोर्ट डिसीजन फॉर डिफरिंग विथ पेंशन रूल्स your muteness is profound.
This is the
High Court cannot pass an illegal order. Suppose High Court has followed a decision.
Rightly, wrongly, already be in pass the order, but till yet, my lord, in writ appeal, that order has not been stayed. And my lord, the honorable the court 6/12/2025 last order.
You have been asked to sue the High Court relying on the Supreme Court decisions to allow provisional pension to be a convicted person.
This is the sympathetical ground, my lord. The petitioner retired on since 2000. He is not getting and age about 62.
You fix your time and you make your submission, no difficulty. Because you are giving an impression as if I am not hearing you. After hearing you and understanding your proposition, I am asking you something. In response to Lord, yes, Mr. Digal, you continue. Complete your submission.
No, sir. Only, my lord, one submission, my lord. Kindly say the last order, my lord, 6/12/2024, after filing the writ of appeal.
Was that order passed by me?
No.
So that is the difficulty. That is the difficulty for me. Once the order has not been passed by the earlier bench or coordinate bench, So I cannot justify that order. Yes. Carry on your solution.
In this order, my lord, I am. May I read, my lord?
Sir, please. Yes, sir. You are free to read anything. You at your choice.
For which time is allowed to the opposite party for full compliance of this order dated 25/11/2022 passed in WPC number 27/7/18 by 2022. List the matter on 10/1/25 if the meanwhile this court order is found to have been not complied with, the court will consider initiation of the contempt proceeding against the opposite party.
What about contempt of Supreme Court and division bench?
In writ appeal, there is no stay, my lord.
No. By defying Supreme Court's orders and division bench orders where the court have held that pension cannot be granted as a matter of right for a person convicted. So what defense of those orders is?
I will verify, my lord.
There is a recent direct decision. Recent direct decision on this. Supreme Court has held that the High Court cannot, one petitioner or the other, violate court's order by saying that it is distinguished. So now the problem is that I asked you that question, but instead of answering that, you went everywhere. I have specifically asked you, again I am repeating for the fourth time, has the court relied on any Supreme Court decision to allow pension to a person convicted of an offence? The reason is very simple. The court of jurisdiction, criminal court, cannot be overridden by an administrative order. So the first question, if you remember, I asked you, then what would happen? Suppose the person gets acquitted, he will get everything as far as if there is no DP or otherwise. If he gets acquitted, he will get everything as arrears. But how it can be granted? Suppose he is convicted, can he refund that? He cannot. On the face of, because this approach of a court amounts to violation of Supreme Court's order and division bench orders. Which decision of the division bench has said that, suppose there are division bench judgments, that in case of conviction, pension cannot be paid as a matter of right. Even to the extent honorable acquittal, it has been discussed. What is honorable acquittal? In which case the conviction was stayed? Have you read anything?
This might read.
Which case? Which famous case?
Penalty of the petition.
Conviction challenge करछन्ती. आपण conviction challenge कले High Court रे.
आज्ञा.
Conviction stay हिची.
Stay हिची.
पढ़न्तु.
Fine टा stay.
Granted bail.
So file टा आने criminal appeal file टा.
ठीक अछि, I can predict it. If you notice, the sentence is stayed, there shall be stay of realization of fine. So conviction is never stayed. But in one case, the conviction was stayed. Which is that case? By Supreme Court. There are cases, but that context is different. But there is a direct bar in the provision, that's the problem. There is a direct bar, and there are decisions that the pension cannot be granted. A member of parliament went to Supreme Court, said that if the conviction is not stayed, then I will be disqualified. In that case, it was stayed. Conviction is stayed in rarest of rare cases. High Court never stays. ଆପଣ ଦେଖିବେ ଏଇଟା ଆପଣ ଯୋଉଟା ଆଣି ନାହାନ୍ତି କହୁଛନ୍ତି ସେୟା ହିଁ ହେଇଥିବ
stay
ନହେଲେ ଆପଣ what Mr. Sahoo is saying that you are granted bail. The conviction stay ହେଲା bail କଣ ହବ ଆପଣ ବୁଝିପାରୁଛନ୍ତି conviction punishment stay ହେଇଛି ସେଥିପାଇଁ ହେଲା ସେଟା ହଉଛି ଆପଣ ବୁଝନ୍ତୁ.
So far the order relies on another order, Millard. That was the case where he was getting provisional pension. That was subsequently because of conviction. It was probably
Whatever, sir.
Yes, sir.
I can pass that order because I don't have to pay from my pocket. This is your money. Whatever tax you are paying. So that is a different thing.
That should have
on rely kala. You are struggling now. We are struggling by relying on which Supreme Court order, High Court order. The payment was pension was allowed. Because ଆପଣଙ୍କୁ ବି ଦେବାକୁ difficult ହେବ. Suppose you are convicted again, then you will go to Supreme Court. Supreme Court will not pass that order payment of pension. ଆପଣଙ୍କ conviction upheld ହେଲେ କ'ଣ କରିବେ? It will put you to immense hardship. Can you collect that money and repay it? There is a possibility even you can claim interest ସେଟା court ଦେବେ କି ନାହିଁ ଅଲଗା କଥା. On delayed payment. But delayed payment ରେ interest ମିଳିବନି କାହିଁକି ନା there is a provision. There is a provision authorizing stoppage of pension. Only. Verify. Last slide. It is submitted by the Lord AC that the petitioner in the present application was convicted. कौन sentence टा कौन ହେଇଛି କୋଉଥିରେ କୋଉ offense ରେ?
convicted on 62 years conviction.
Was convicted by the judgment of the appropriate court in a criminal proceeding. Therefore, in view of the specific provisions in Rule 6 and Rule 7 of the pension rules, the pension was stopped and the state authorities have moved in appeal. And the state has moved in appeal, challenging the order passed by the Lord Single Judge directing payment of pension, provisional pension. Pension provisional pension to a retired government employee who has been convicted of an offense. The Learned Counsel for the petitioner submits that the order has been passed. The Learned Counsel for the petitioner was asked whether the Learned court has, while directing payment of pension to the petitioner after his conviction by a court. In response, he submits that provisional pension was granted on sympathetic ground. The petitioner in appeal has moved the court challenging the order of conviction. The sentence and the realization of file has been stayed. The Lord Counsel for the petitioner has adjournment to verify whether the conviction has been stayed by the court. List in the week commencing? No.
time there.
अरे मु कौन सेडा मु कौन रिटेपिल धरछि अपन काई व्यस्त होचुंदी मु एटा कोन रिटेपिल ना कोन रिटेपिल हेतले अपन अधिक टाइम नै थान एनीवे डिफिकल्टी किछ नै काना से भी जानि नाहंती कोन ताकर 23/2 द वीक कमेंसिंग 23/2 ना केबे चाहुछन
First week
23/2 था फर्स्ट वीक ऑफ मार्च द लॉर्ड काउंसिल फॉर द पिटिशनर 6 times as prayed for list in the week commencing AK commencing 2 March 2026. Yes, next.
26.
This notice was issued on 10/9/2025.
Any report has been received regarding service? Mr. Alok Kumar Ponda for the petitioner. By order dated 12/11/2025, copy of the order was forwarded to the office to the Learned Judge the Learned Judge Family Court, Women's Court Hon'Ble.
Learned Assistant Session Judge.
Learned Assistant Session
Women's
Judge
Court Hon'Ble.
into bracket Women's Court Hon'Ble. For the directing to cause service of the copy of the order on the Learned Counsel appearing for the opposite party herein, who is the petitioner in CMA into bracket CMC number 49 of 2021 and CMC number 25 of 2022. Counsel oblique लिखिए petitioner. The opposite party oblique her counsel. The report is awaited. Registry shall issue a reminder for obtaining report from the Learned Judge, Learned Assistant Session Judge, Women's Court,
Hon'Ble.
Yes, Hon'Ble. List in the week commencing 16/2/2026.
The liberty was granted to take adjournment. That may be
Co-order
10/9/2020.
The Learned Counsel for the petitioner refers to the order dated 10/9/2025, wherein the coordinate bench had observed that as indicated in paragraph 10 of the said order. Order as contained in paragraph 10 of the order dated 10/9/2025 is also reiterated.
Next.
Yes, next.
27.
May I please your lordship that the petitioner is a wife and a minor daughter, my lord. That the annexure 3, my lord, execution case is pending before the Judge Family Court, Bhubaneswar, my lord. Now the petitioner is staying at Cuttack, my lord. So let me transfer, my lord, this case, my lord, because the husband is also threatening to me and withdraw the case. And the notice is also be gone. And in the meanwhile, they also be acquittal, my lord. Baripada jail रे थिले वर्तमान से acquittal ହେଇକି ଅଛନ୍ତି.
ସେଟା ତ ଆପଣ ଚିଠା ମାନେ ମତେ କାଗଜ ବଢେଇଲେ ହବନି, ଆପଣ ଗୋଟେ ରେକର୍ଡ କୁ ଆଣିବାକୁ ପଡିବ। ଆପଣ ବାରିପଦା ଜେଲ କୁ ଯେ ନୋଟିସ ଯାଇଥିଲା, ହଁ, ସୋ ଆପଣ ଯଦି କିଛି ସବସିକ୍ୱେଣ୍ଟ ଡେଭଲପମେଣ୍ଟ ହେଇଛି ଫାଇଲ ଆନ୍ ଆଫିଡେଭିଟ ଇଣ୍ଡିକେଟିଂ
Yes, my lord. I have given to the affidavit also be filed.
ସେଟା ଦିଅନ୍ତୁ, ଏଠି କାଚ ଭାଙ୍ଗିକି ଭର୍ତ୍ତି କରିହବନି, ଫାଇଲ କରନ୍ତୁ, ସେଟା ଆସିଯିବ ସ୍କାନିଂ ହେଇକି। ଆପଣ ବୁଝିବା ଦରକାର ଯେ ଫାଇଲିଂ ଟା ବର୍ତ୍ତମାନ ଚେଞ୍ଜ ହେଇଗଲା, ଇଏ ନେଇକି ତାକୁ କିଛି କରିପାରିବେନି।
ଆଚ୍ଛା ଆଚ୍ଛା,
ସେଟା ସେଠି ଫାଇଲ ହବ, ସ୍କାନିଂ ରେକର୍ଡ ତାପରେ ଆସିବ। ଅସୁବିଧା କଣ ହବ ନା ଯଦି ଆପଣ ଏପଟ ସେପଟ କରିବେ, ମିସପ୍ଲେସ୍
notice will be sufficient, my lord. AD मुझे फेरी your lordship may kindly see your lordship. Previously से बारिपदा कोर्ट रे नोटिस टा पाई नथिला बोली कहले, नोटिस टा न आसबारे एबे वर्तमान सेटा ट्रैकिंग रिपोर्ट आसी जाईची, दैट इज सफिशिएंट माय लॉर्ड।
ଆପଣ ପୁରା ଅର୍ଡର ଟା ପଢୁ ନାହାନ୍ତି ଆଉ।
माय लॉर्ड 19 तारिख
ବାରିପଦା ଜେଲ ର ସୁପରିଟେଣ୍ଡେଣ୍ଟ କୁ ଗୋଟେ କଣ ଡାଇରେକ୍ସନ ଥିଲା,
डायरेक्शन थिला, नोटिस टा मुझे जाईथिला योर लॉर्डशिप। से नोटिस ऊपरे कोआ हला जे आज्ञा माने
पाई जाइछन्ती, आपण जे सेटा देखि थांते ହେଇଥାନ୍ତେ।
हां पाई जाइछन्ती,
ସେଇଠି रहू आपण ଆଉ। ते जेल रे थिला भितरे,
हां
नोटिस पाइचंदी
Yes, my lord.
तापर से एक्विटेड है कि बाहरी होले
हाँ, yes, my lord.
तो सेटा रिलेवेंट कोन होता ले सेटा आज दरकार नै
नहीं मु कहूची योर लॉर्डशिप माने कहली
आपण खुशी तक आपण स्वामी बाहरी होले बोल तो भलो कथा
ना भलो कथा किंतु सर मते पैसा दउ नांती
ठीक अछि आ कोन
तेनु को ट्रांसफर हे गले सर मु कट
हैप्पी फॉर हिम ही हैज बीन एक्विटेड
Yes, my lord.
by earlier order dated 29/11/2025 the coordinate bench had directed a report to be obtained from the superintendent circle jail Baripada at Mayurbhanj regarding notice issued in the present petition by speed post with by speed post stop kar diyo. The senior superintendent circle jail Baripada by his letter dated 11/12/2025 addressed to the registry has intimated that the notice in TRP CRL number देखिए देख परियो एटा flag carrier notice in TRP CRL number 83 of 2025 containing 9 seats has been acknowledged by the then under trial prisoner opposite party. It is submitted by the Lord Counsel for the petitioner that in the meanwhile, the opposite party has been acquitted of the charges for which he was an under trial prisoner in the Baripada Circle Jail. In the Baripada Circle Jail. Stop. So, से कोठी बेरो नौचंदी पर
वर्तमान से एकुटल वर्तमान से
आई थिंक से अन्य को केस रे अपियर करचंदी की लोअर कोर्ट प्रोसीडिंग किछ अछि की जोते कि करि हबो
नहीं आउ कोठी प्रोसीडिंग से जजमेंट हे गेला एकुटल हे गेली योर लॉर्डशिप से भुवनेश्वर रछंदी वर्तमान मो स्वामी किंतु नोटिस पाइला पर मु तांको भेटिली किंतु कथा बात
अंडर ट्रायल थिले कोन आपण केस करथिले
नहीं से अलगा केस रे पोस्को एक्ट रे माय लॉर्ड से पोस्को एक्ट रे अलगा केस है मु कर नथिली
पोक्सो एक्ट रे
हां पोस्को एक्ट रे मो स्वामी जेल वाला
पोस्को पळे लागा सित पय कोन पोक्सो को पोस्को कहले बोली पोस्को छाडी पळेला
माय लॉर्ड जे दोष कला से दंड पाइबो किंतु से दोष
पोस्को किछि दोष करनी
इन द मीनवाइल माय लॉर्ड
पोहाल आयरन एंड स्टील कंपनी कोन दोष ताई
माय लॉर्ड ट्रांसफर न होले ठीक तेनु के मु सेटिस्फाई
कोरियर से एक्ट भी नहीं कोरियर कोन इक्विवेलेंट एक्ट अछि पोक्सो रो I will going little bit too fast for you. Anyway, on like Circle jail and was in custody and was in judicial custody in Baripada Circle jail. तापरे बर्तन कोन करा जियो ताले
सर तापरे माय लॉर्ड से कुटल हे जाइछन मुडे माने
आउटर नोटिस नेबे ना अवेट करिबा सेटा खाली कोन
नहीं वेट नहीं माय लॉर्ड से दैट इज सेटी सब
जो डिस्ट्रेस कंडीशन रे जेल रे गथिले जेल इज फॉर नॉट फॉर ह्यूमन बीइंग सर
my lord say
when we have started visiting and because it's an integral part of judiciary to visit and supervise the conditions of prisons so many directions by Supreme Court and
my lord say
about the time due to them
yes my lord you may be time
the awaiting sufficiency নহলে you can take notice afresh जोटा कि जल्दी हे जान যদি authority you take instruction I am not asking you today but you think in those lines
my lord client is standing in out of the court my lord today he is
opposite party एठी अछंती
नहीं मो पिटिशनर अछंती माने से एफिडेविट
whatever you decide only awaiting appearance of the opposite party list in the week commencing 9/2/2026 से बर्तमान 11/2 रे बोधे परे बाकने 11/2 रे से जेल रे थिले आगे
सर से 22/12/2025 रु एकुटल हे गेले
let him gather his world sir his world is in completely disarray
yes
आपण जे से थिले जेल रे आपण ता नोटिस पठे देले से फिर आपण ओळिया माने कड़ा नोटिस ठीक अछि असु देखिया जदी by the next date you suggest in the outer line add कर दियंतु in the meanwhile if the petitioner so advised may take notice afresh to the opposite party in his present correct address it is up to you
सर केते पैसा खर्च करियो सर से तो
पैसा तो मु कहली नै आपन So I have been struggling to tell you that whether you will take notice or not, you talk to your client.
notice नहीं करी मैंने से.
Third, the last line काटी दियो. Which leads to advised.
नहीं.
I have not directed.
Yes ma'am. No दो ही की रहो.
ठीक है जी देखिए.
Oblige.
28.
Mr. Subhasis Patnaik for the petitioner. Mr. R.N. Parija for the opposite party. Hearing kari beta. This is for admission.
There are two RPFMs. One is 216 by 2000.
Mr. Parija epotu pare asantu. Are apon ghunchi gale set.
There is another application.
One impugned order. Two RPFMs. One has been filed by me for enhancement, and they have filed, and I am for the wife. They are for the husband. They have filed 241 by 2025.
List है नहीं.
241 टा list है शुक्रवार ना सेटा आसियो second week second March week commencing 2nd March 2026.
মানে এই বেঞ্চ রইতলা
না
নো নো কোড না কোড রইতলা
অর্ডার একটা দুইটা আসলে সুরা
দিটাঙ্ক একাডি আছে
খালি আর গোটিয়ে মানে যেতে ক্লোজ অছনি সেমতি এই যে পার্টি ক্লোজ করে দেউ নাহাंती that should reflect on the parties also. कई big cases किसी meaning नहीं आएगा 125 रे
these are the
seasoned enough and senior enough to arrive at a solution. These cases have no future. जो pendency आपनकर सब बेले हमको pointed करा उचित से correct and so many cases are pending for the माने आज उड़े 23 रो 3 वर्ष पर notice sufficient है आज उड़े matter 125 थरे फाइल कले नोटिस इश्यू हेले से केस पड़ी की रहना अल्टीमेटली तो किसी होनी तो यूज योर गुड ऑफिसेस लेकिन अपीयरेंस एंड डाकिंग मिस्टर सुभाषिस पटनायक मिस्टर आरएन परिजा ना it is stated by the Lord Counsel for the petitioner as well as the opposite party that the opposite party has filed application RPFL
241 by 25
241 of 2025 challenging the self-same order, granting maintenance under section 125 CRPC into bracket since repeal. Complete. Stop. The present petition has been filed by the wife petitioner for enhancement of the wife and child.
Wife only.
Wife petitioner for enhancement. The body happened to full stop. Accordingly, the present matter shall be listed along with RPFM, which has been directed to be listed in the week commencing
2nd March 2026.
2 March.
2nd March. We commencing 2nd March.
We commencing 2 March 26. But 2 March से अपन को बहुत थोड़े छुट्टी अच्छी. जब 3 days week set. Anyway, ठीक है. 2 March 48.
सिला गोटे खाली पॉइंट गोटे जिंस रिक्वायरमेंट सिला पैराग्राफ 10 of the order टा खाली देखिए पैराग्राफ 10 इंटरनल पेज 88
और इंटरनल पेज 88 of petition
आ गया मोर ब्रीफ 216 by 2025 impugned order paragraph number 10
just give me a moment I'll get there. '88 paragraph 10 yes both the parties had filed yes
disclosure statement of affidavits and liabilities
16 days and no 125 rate and no problem which is you are arguing as if it is a 25 application when 125 DV Act 25 24 are taken up together then Rajneesh versus Neha steps in but look at the 125 upon production of such negligence evidence yesterday day before yesterday one matter was argued by the from Sambalpur. It is a 20-page order. But I just requested the Lord Counsel that you could please place on, just show me so that I'll get educated that where the in 125 or 24 petition, Rajneesh versus Neha analysis is to be made. Because for interim arrangement, if you make this kind of a provision, Rajneesh versus Neha, then it becomes a never-ending process. If you use the, kindly look at the language used in 125 CRPC. A magistrate of the first class may upon proof of such neglect or refusal order such majority where such child is beyond region of physical so and so, so and so. So the magistrate is to look upon proof of such refusal to pay maintenance. Then how Rajneesh versus Neha can be read into this? Rajneesh versus Neha has a context because every time one adjudicating the 25 petition seeking permanent alimony, both the parties are actually not giving a clear picture. The husband says, I am a pauper. Wife say he is a prince. And I was living a life because the 25 language is the status of a wife. I was living the life of a queen when I was married. So I continue to be a queen. So Sejagare say there is a purpose, but that it has some difficulty. But now 24 order, still the CP is pending. 24 order runs to 20 pages. So because of you arguing, then the judge is blamed. With the extent to argue କରିବା କଥା ନୁହଁ ଆପଣ ଗୋଟେ reasonable amount of satisfied ହବା କଥା which shall be subsumed in future order. Even 125 is not a strictly a persuasive factor, but obviously you can say the court that I have paid so much of amount in 125.
I have already paid. The coordinate bench has ordered to pay 30,000. I have already paid.
It has to be that way.
Interim arrangement.
It has to be that way.
Interim arrangement.
It has to be that way. But if you argue as if you are arguing the file suit, 125 is never a suit.
ସେ ଆସୁଛି
ଦେଖନ୍ତୁ କଲ୍ କର
29.
Mr. Be submitted by Mr. Appearance Lekhibe. Anyone present for the petitioner? Petitioner blank Lekhibe. Blank. Opposite party, Mr. Sanket Swarup. ସେଟା ନାହିଁ ତାକୁ ସେଠି ଭୁଲ ହେଇଛି ଆପଣ ଅର୍ଡର ଲେଖନ୍ତୁ Mr. Sanket Swarup for opposite party. It is submitted by Mr. Sanket Swarup, learned counsel, that his name has been wrongly mentioned as S.Sahoo, whereas S.Sahoo in the cause list as well as the case brief. Whereas he has filed Wakalatnama and his name is Sanket Swarup, which may be abbreviated as S.Swarup. The registry shall do the needful for correcting the name of learned counsel, Mr. Swarup, in the cause list as well as the case brief. List in the week commencing 2/2/2024. Yes,
Item 30.
I am for the petitioner. So
whereas other matter, could you get the document?
Lordship.
Okay. Yes, you are Mr. Swain.
Yes, Lordship.
Mr. J. Swain for the petitioner, Mr. R.C. Ramchandra Mohanty for the opposite party. Yes. Ready for hearing?
Sir, I pray for adjournment.
This is again 125.
Lordship.
Sir, use your experience to settle these matters. RPFM 125 रे आपनकर 30 यदि 30 पेंडिंग अछि सॉरी 13 पेंडिंग अछि सेतरे कोन ऑर्डर हिची 24 ऑर्डर हिची की
13 है
हां
नहीं नहीं
किछि
सेक्शन 9 टा लॉर्डशिप सेक्शन 9 टा को अलाउ करी के 125 टा को डिसमिस कर
क्लियर दिस सेम डे रे जजमेंट इजी
सेम डे
that's a possibility. I was thinking something else, so that is also happening. So agree for a date. The learned counsel for the 2 weeks. 15th February. Correct. से तो कहते हैं वीक कमेंसिंग हेले सुविधा होची लिस्टिंग पे 16th February 15th February Sunday 16th February. Yeah. The matter is listed for admission hearing. The learning counsel for the respondent seeks accommodation. List in the week commencing 16/2/2026.
Item 31.
Mr. D.R. Deepak Ranjan Sundar Rai. For the petitioner, Mr. Gajendra Nath Raut, G. Raut. For the opposite party, the learned counsel for the matter is listed for admission hearing. The learned counsel, stop. The learned counsel seek further time to advance arguments. List in the week commencing 9/2/2026. List interim order to continue.
Item 32.
Petitioner none, opposite party none. The matter is listed. Acha, sorry, I mentioned got it. I'm so sorry. ठीक है. 32 टा करिवे उकिलों का नाम होना चाहिए.
Yes, Behra.
Mr. S. Behra for the petitioner. Mr. Opposite party, Mr. S.K. Bishwat. The matter is listed for admission hearing. The learned counsel for the parties seek for the time to advance arguments. Stop. Accordingly, the matter shall be listed in the week commencing 22/2026. On 22/2026.
Sir, the 22 ଆମର 230 ଟା 232 ଟା ଥିଲା 13 ଏକରେ 21
21 ହବ.
21
Item 32 धावन 21 list on 21/2026. It is stated by the learned counsel for the it is as submitted by the learned counsel for the parties. The matter shall be listed on the next date. The matter shall be listed along with number tab okay. गोटे अच्छी आ गोटे आसीबो तीटा देखो 232 आसीबो. Yes. Mr. Chattoy.
33. I am the petitioner.
Yes.
Today I am filing an affidavit, and that should be brought in to record. So keep it to. I am serving now a copy of
copy. Mr.
Yes,
Ranjan Chattoy for the petitioner.
And
Mr. Basant Kumar Ponda for the opposite party. Learned counsel for the petitioner files affidavit.
I am serving.
Submits that he shall file affidavit in the registry today. Copy of the affidavit is served by the learned counsel for the opposite party during course of hearing. I don't know. It is submitted by the learned counsel for the file affidavit today. Stop. Copy of the affidavit has been served on the learned counsel for the opposite party. The affidavit shall be taken on record. Scanned copy be updated. List in the week commencing 16/2/2026.
Interim order to continue.
Interim order as passed earlier shall continue till the next date of hearing.
34.
So Prabhat Kumar Mudli for the petitioner. Opposite party क्या appear करना थी?
My lord, we consider the last order. Order number 2 dated 12/11/2025.
Right.
On that date also, even if the notice was made sufficient, nobody entered appearance.
Did you file affidavit that they are staying together in jointness? Because how father receiving a notice can be treated as sufficient to be on daughter or son. Son is also, then here it is.
Father and son both are living in one mess.
But what is the affidavit? The order doesn't refer to anything. And most likely, you are using the counsel to understand that. So you are also.
No, on the basis of noting made by the registry, so this was made sufficient.
Cannot be. This is a high risk thing. On the self-sworn ground, for appearing for the other side, the order more. Because that you have to take. You have to file that affidavit stating that they are living in joint mess. In fact, in one matter, we tried to, in Sambalpur, it was appeal. This, the lady said she never received. So we asked the Postmaster General to intimate the court whether the person has received. They say that it can only be, evidence of delivery. They cannot say who received. The second aspect is very interesting. Whoever has received, that record will be available only at the point of delivery, not here. So probing through the postal authority also did not help. And we had to allow that application.
Notice was sent in the address which was
given.
Divorce proceeding.
CC Alavi Haji versus Palapeti Mohammed. But the problem, once they challenge it, then what is the answer?
No.
But what you can do, you can file that affidavit, let us see that. Here what is happening? You are challenging enhancement.
No. It is a transfer case.
Achha.
At Uddala, 4 proceedings were initiated from 2022. In 2025, as a counterblast to all those proceedings, since execution cases were pending, in order to avoid that all those proceedings, he initiated the divorce proceeding at Balesur, Nilagiri.
So you file that affidavit. I mean, that is not a court direction. I think to justify that order, you have to supplement that order with that affidavit that they are living in jointness. Because I think that's a provision in CPC.
No, since there was no such direction, so in view of
direction darkar nahi. When you are taking notice, if you say that X is staying with Y and X has received notice, postal authority cannot certify that.
Had it been Dasti service, I could have filed the
exactly
service affidavit. This is not a case of Dasti.
So then you have to file affidavit that they are staying in jointness. That chance you have to take. And maybe the husband's petition will be transferred, so that way it will help. Next date record the allotted counsel for the petitioner refers to the order dated 12/11/2025. But the coordinate bench, by the said order at paragraph 3, has observed thus. The said order, apparently, the said order relied on the office note put up by the registry, dated which reads, Mr. Muduli, you just look at the office note. Office note doesn't state that. Click the bookmark. Serial number 2. Quote, the AD returned with signature of one Sri Kartika Sahoo, relationship mentioned as father of the address. There is no further. Shall I observe or I leave it there, Mr. Muduli? Upon file call up, then I will consider. The Lord's counsel for the petitioner seeks adjournment to obtain instruction. Kibe, list in the week commencing.
Week commencing 9th.
9 February 2026.
There is an exam.
सेठी से appear करचोदी सेठी अपन notice नहीं जान जोटी सी appear करचोदी सेटा अपन ओटे memo file करी सेठी नहीं जान. That is also, you take that instruction. Wherever he is appearing.
So in all those criminal proceedings, he is appearing. But my lord knows how the trial court lawyers are. But I don't have any instruction to receive.
They are the interface. They are greater than us. So if you tell me as a member of the bar, so there is no here there.
So there is a provision in CPC to serve through the land counsel for appearing for the party. But he will say,
Justice Sinha every time made ensure that a copy has to be served on the counsel appearing. Because that last line in that Vokalatnama, that it is very clear also. Even if he says that I don't have instruction because brief has been taken away, but let it be served.
No, even if he's appearing in the pending
No,
cases also.
in his petition, one strategy is that in his petition you serve it through that court because that can be directed by High Court. You take that instruction. If he's appearing, then we'll serve it to particular court where he is appearing. He is the petitioner. Divorce in Udala.
In the divorce proceeding, I will try to serve the counsel who has filed the divorce proceeding. So if he accepts, it's well and good.
No, because there will be court direction. Court direction is better.
No, let me offer in the first instance, along with the copy of my lord's order.
Yes. Which is the week commencing 9/2/2026.
Interim order.
Interim order dated 9/9/2025 shall continue till the next date of hearing.
Item 35.
Ms. S. Samantray for the petitioner.
My Lord, just now I received the counter copy.
Okay. Ms. S. Das for the opposite party. The Colonial Counsel for the petitioner submits that she has received copy of the counter filed on behalf of the opposite party in the court today. Stuff. She seeks further time to obtain instruction and file response if so advised. Na. केबे आसले हो? डेट करंतु. Next to the week commencing 16/2/2026.
Lordship, interim order is there.
Interim order passed earlier
Yes, Lordship.
shall continue till the next date of hearing.
36.
I am for the petitioner, Lordship. Lordship, last order dated 11/11/25, 4 weeks time was given to the opposite party to file counter. We have not received any counter yet.
Okay.
Here is the case, my lord, visitation right of the husband. Your lordship will kindly see the order which was challenged, what counter I will file. Your lordship will kindly turn to
No, since there
case
is
24.
24.
24. Last line. Both the parties have filed their petition for modification of the order. The application filed by the wife was disposed of, whereas the application filed by the husband has not been disposed of, it has adjourned to some other. They have challenged this order. Their application has not yet been heard.
You are Mr. Sahoo or Naik. Your name, sir?
My name is Shubham Ghosh.
Mr. Shubham Ghosh on behalf of Sarabala Jena for the petitioner. Sorry, item 36. Shubham Ghosh. Yes, Jena for the petitioner. Ms. Dipali Mahapatra for the opposite party. Yes, what do you say?
No, sir.
You obtain instruction.
Yes, sir.
One thing, since there is a judicial order, he has every right to say that.
Then
Your point is well taken. Your point is well taken. So you can simply what you submitted today, that can be the affidavit also. One paragraph. That the matter is kept pending, but still it is challenged before this court. That is the sum and substance of the submission.
Your lordship kindly see it.
Yes. And your learned
And he is challenged.
young friend has also read that, so I could mark from his expression. But if he was reading it, so he could not answer what you said, that though it is yet to be heard, but still it is challenged here. The learned counsel for the petitioner refers to the order dated 8/9/2025 passed by the coordinate bench and submits that counter on behalf of the opposite party has not been filed.
Order dated 11/11/25, Your Lordship.
Man, check, sir. When the court is looking at something,
Okay.
I'm trying to read.
Yes.
You should use. This is for you only.
Yes.
8/9/2025. Counter has not been filed. The learned counsel for the opposite party refers to the order impugned last paragraph, that is at page 29 of the brief, to submit that.
24.
Sorry, 24 of the brief, to submit that the matter is still pending to be adjudicated by the learned Judge Family Court Puri. And at that stage, and at such stage, the petition has been filed challenging the order. Which had directed for consideration of the petition filed by the petitioner. CTC petition, husband also the petitioner.
Yes.
Aye.
Husband petitioner in the said CP. List in the week commencing 16/2/2026.
Obliged, Lordship. 37.
Mr. J. Mahanti for the petitioner. Ms. S. Patra on behalf of SK. Ruplal for the opposite party. Number 1. The learned counsel for the matter is listed for admission hearing. The learned counsel for the parties seek other time to advance arguments. List in the week commencing 16/2. List in the week commencing 16/2/2026.
38.
Your matter, Mr. Jennings. Mr. S.K. Jenna for the petitioner, opposite party mention करते लगी?
No.
Opposite party none. The matter is listed for admission hearing. List on. केबे कहले?
16/2.
This is the week commencing 16/2/2026.
39.
Mr. Alok Kumar Mahanti for the petitioner, Mr. S.R. Acharya for the opposite party. Let us simply adjourn. Order किस करो तो? से confuse है कि अच्छा ठीक है. We are leaving it, Mr. Sethi, because there so many submissions are made. Better to leave it there. Yes.
Item 40.
Mr. Mishra.
My lord, here my lord, copy was served on 18/11/2025. I am having
the receipt you file it in the registry?
Receipt I am filing the registry.
Okay. Mr. Vibhuti Bhushan Mishra for the Abhimanyu Polda was present in court. I saw him, I think in the morning. Okay, anyway. Maybe he's Mr. B.K. Polda, not Abhimanyu. Mr. Vibhuti Bhushan, he's not your associate. He's for the other side.
Other side.
Abhimanyu Polda
is for the other side.
Okay. Mr. Vibhuti Bhushan Mishra for the petitioner. For the appellant. It happened. Direction को order थिला Mr. Mishra?
Direction last order 17/11/25.
It is submitted by Mr. Mishra, Learned Counsel for the appellant, that copy of the appeal memo has been served along with a copy of the impugned judgment as directed by the coordinate bench by order dated 17/11/2025.
On 18/11/25.
जो शॉर्ट लिख रहे नहीं शॉर्ट ऑन 18/11/2025 the memo indicating of the service of copy shall be filed in the registry during course of the day.
Yes.
During course of the day, the said memo shall be taken up on record, scanned copy be updated. The matter stands ऊपर सभा opening line लिखियो, the matter is listed for hearing. Last day लिखिए, the matter stands adjourned to be listed in the week commencing.
Disposed of
February na March के बेच होंगे. February को से.
Sorry जानता है.
We come to 23/2/2026. Mr. Mahanti, your matter is simply no order is passed. You can make a mention for listing before the assigned bench. যদি ଚାହୁଁଛନ୍ତି ସେ କହିଲେ ଆପଣ ଗଲା ପରେ ଆସିଲେ ଆପଣଙ୍କର ଥାର୍ଡ ପ୍ଲେୟାର ଫାର୍ଷ୍ଟ ପ୍ଲେୟାର ସକାଳୁ ତାଙ୍କର ମାନେ ଆପଣ ନଥିଲେ ସେ ଅର୍ଡର ଆର୍ଜନ କରି ପଳେଇଲେ, ଆପଣ ଆସିଲେ ତାପରେ ଆଉ ଗୋଟେ ଅର୍ଡର ହେଲା, ସିଏ ଆସିଲେ କହିଲେ ଆପଣଙ୍କର ମୋର ମାନେ ନାହିଁ ଡିଟରମିନେସନରେ ନାହିଁ ଏଟା, so I am not passing any order. So better if you mention before the deputy registrar, he will do the needful. ପାସୋଭର ଅର୍ଡର ତ ହେଇଛି, ଯଦି ଭେରାବ ଆସିବ ତ ଡାକିବେ ଆଉ ତ ରିଜ୍ୟୁମ୍ ଆଜ୍ଞା ଅର୍ଡର ବ୍ୟାକ୍ ଅର୍ଡର କରିଦେଇଥାନ୍ତି ହେଲା। We may resume for item 9 because we have passed it over. He has not come, he mentioned, so we may resume. Yes, please.
Always.
No, not
Local unions.
Why should you be, sir? Please don't be apologetic, sir. Then. Yes.
For
Kindly call.
On 30th November 23, notice was issued. The date of appearance was fixed to 5/1/24. On the very same day, the notice being treated as sufficient as he has been set expert. And thereafter proceeded with the expert and
9/5 is important.
Okay.
Sorry. Am I clear? 9/5 order is important because if you now look at that order where they have granted 125.
Okay.
So 125, the evidence has been adduced.
125 evidence.
125 evidence has been because the court refers to that evidence. Please look at that order.
Yes. Yes.
Order se likhichanti.
Para 5. In order to substantiate the relief sought by the petitioners against the OP, the petitioner 1 has examined herself as PW1 and her mother as PW2. She has proved 2 documentary evidence as Exhibit 1 and Exhibit 2. Exhibit 1 is birth certificate of son, where his father name is not there. And
the problem is that is a contemporaneous document that has been proved. So it's not an easy order to pass to say that it is. So there is some other issue.
Yes, ma'am. Exactly. Other issue.
So what you do? Total amount kete helani?
Total near about 5 lakhs area. I am ready to, without prejudice, I am ready to deposit 50% instantly. Within some time may be given.
Because the language used in 125, can you read 125?
Yes, ma'am.
I did you. That's what they do. CRPC ta eta. এটা 144 না 125
new act kind of because it is
এটা new act
judgment ହେଲାକୁ ସେ ରେଫର କରିଛନ୍ତି 125 to 144
ତାହେଲେ ଆର ବଟା ଦିଅ
କରିଛନ୍ତି
ଆଜ୍ଞା କୋଠି ଅଛି
ନା ଏଭିଡେନ୍ସ ହେଲା ବେଳକୁ new act has came into force. Order for maintenance of
B. 125B.
In 125.
Anyway, what put order of maintenance?
Order for maintenance of wives, children, and parents. If any person having sufficient means neglects or refuses to maintain his wife, unable to maintain herself, or his legitimate or illegitimate minor child, whether married or not, unable to maintain itself, or his legitimate or illegitimate child not being a married daughter who has attended, this is not the case, his father or mother, this is not a case, a magistrate of the first class may...
His legitimate child married daughter gala.
Okay. A magistrate of the first class may, upon proof of such neglect or refusal, or such person to make a monthly allowance for maintenance of his wife or such child. Here, no documentary evidence. No.
Child. Your problem is that Prabhat Ranjan Naik is fully entitled. You may deny Rita Naik. Suppose, let us assume.
Yes.
Right now, that is because that's not the case because he has adduced evidence.
Yes.
So it is a determination by the court.
Yes. The son, the birth certificate which has been exhibited does not bear the name of the father of the petitioner.
Sir, that will say institutional, but there are so many issues. the birth certificate, if it is not mentioned, so we cannot, the court
That
cannot
can be
presume that.
established. That can be established.
Evidence and presumes. There is a
On
presumption.
evidence.
Yes.
On contrary evidence.
And in many cases, it is reported birth. It is done at home, then reported to the authority. Institutional institutional birth is that at a place of that prenatal care or in a hospital or in a nursing home. They are reporting it.
Exhibit hospital land.
Correct, hospital. So they have to disclose that. There are so many reasons.
Matter is.
So how much time you will take to deposit that amount?
50% your lordship may direct 50% of the area about. Your lordship may said 2.5 lakh, 2 lakhs.
Sufficient. He did not appear and he was satisfied by the transfer which is submitted by the petitioner. That the petitioner is now received execution of this government and also the petitioner submits that the petitioner disputes marriage and it is further submitted as a petitioner marriage to another lady.
Has married to another lady.
And two children are born of this said wedlock. And this stage.
At this
Much
stage,
prior to
that the Lord counsel for the petitioner that without prejudice to the rights and contentions. Type type without prejudice to
the earlier matter.
সেটা ঠিক আছে করিবে তখন তো করবে না
স্যার সে যে
কথাটা লিখুন
স্যার
this is the learned counsel for the petitioner submits that without prejudice to the rights and contentions of the by the learned counsel for the petitioner that without prejudice to his rights and contentions in any pending proceeding including the present proceeding he shall deposit rupees 2.5 lakhs before the learned executing court. The said amount कौन लिखले executing court है तापर लिखंतु he prays for 2 weeks time. He prays for 3 weeks time. Prays for 3 weeks time. Accordingly, it is directed if the petitioner, present petitioner, who is the judgment debtor in CRP execution case number 28 of 2025, pending before the learned judge family court, Kendrapada, makes a deposit of rupees 2.5 lakhs by आज होची केते 15 तारिख 3 weeks हेले 15 22 29 5 February.
By
12 February 2026. 4 week कर देवे हला. A week, D week, 3 week, 4 week, 4 weeks कर देवे हला. हाँ. The said amount shall be kept in a
interest
bearing fixed deposit. The credit of the execution case that shall abide by further orders to be passed by this court. It is submitted that the matter, the execution case is posted tomorrow. Date
16th.
Tomorrow, that is 16/1/2026. It is upon instruction, the petitioner, upon instruction, it is submitted by the learned counsel for the petitioner that the petitioner shall file application seeking adjournment. In case the application for amendment is filed, the application for adjournment is filed before the Lorded Court in the execution proceeding 124 of 20.
Execution proceeding was 28 by 20.
28 of 2025. The matter shall be adjourned. What time then?
10th, 12.
Shall be adjourned till 23rd of February 2026. List in the week commencing. Stop kar diyantu. Tapare the present petition shall be listed in the week commencing 16/2/2026. এটা নিয়ে যাবে। Yes.
Marriage much prior to this incident. See, he has married since 1998.
Sir, he could have got married after getting after his birth also, but that is not relevant. Sir, ଆପଣଙ୍କର ଯୋଉ ଆପଣଙ୍କୁ ଥିଓରି କହୁଛନ୍ତି ଯେ ଯେହେତୁ ସେଠି ବାହା ହେଇକି ଏଠି ବାହା ହେଇନି ତାର କଣ ରେଲିଭାନ୍ସ କଣ ଅଛି ସାର୍?
ମୋର ବହୁତ ଆଗରୁ
କେବେ ସେ ତା ଆଗରୁ ବାହା ହେଲେ କି ତା ପରେ ବାହା ହେଲେ how does it matter?
ନା ସେଟା ତ
So that is how 125B is there. Son ପାଇଁ ସେଥିପାଇଁ କରାହେଇଛି।
notice
ତାପରେ ଆଗ ଲେଖିବେ issue notice along with this order to the opposite party. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. The fixing the returnable date shall be fixed to be 9th of February 2026. Fixing returnable date 9/2/2026.
Much of it possible.
Yes.
Can I break the order? Can we?
Yes.
Or I can.
Hopefully it will be done. It will require some correction because it has become. Opening sentence lekhibe, the matter was passed over. The matter was passed over at the instance of the London Council for the petitioner to enable him to obtain up-to-date instruction. Later, the matter was taken up. Yes, and the following order is passed.
And the adjournment person shall be filed along with the website copy of this order.
Yes. Parties to act upon line add kar diyantu. Parties to act upon website copy, the copy of the order obtained from the official website of this court. Parties to act upon copy of the order obtained from official website of this court. Tago kar debe. Yes.